going to have Andrew talk to us to explain a little bit about what's happening at 3 when we're being joined by the Arbitration Advisory Committee, which should be interesting. And I think that's it. I don't have any other announcements.
Okay.
Staff report.
Thank you. So really quickly, the 2 opinions that were out for public comment have come back from public comment. The public comment deadline was November 26th. They are in your materials. We received 1 comment on 12-0005 from Richard Zitrin, and I believe that was the only comment we received on either of those 2 opinions, which we'll be discussing shortly. 14-0004, witness perjury, is out for public comment. It has a public comment deadline of February 27th. We've received 2 public comments, I believe, thus far, and we will continue to forward those to the drafting team as we receive them. On Wednesday, this past Wednesday, the State Bar's Task Force on Access through the Innovation Legal Services had their first meeting in San Francisco. It is a majority non-lawyer member task force, and it's going to be directed through a subcommittee process. There'll be a group of 3 subcommittees studying discrete topics, and each subcommittee's work will bring their recommendations back to the full group, and they are tasked with studying whether changes to regulations within the state and regulations with respect to attorney conduct could be augmented to increase, I got some feedback, could be augmented to enhance access to legal services within California. So we encourage you guys to follow that process. Any recommendations that are made are expected to go out for a public comment period. That should take place if we keep to our schedule in June or July of 2019, and I'm sure this committee will be looked to provide comment on any recommendations that happen to be made. The other thing to mention is the Ethics Symposium is coming quickly. You wouldn't think so. It feels like we just had it. It's in April. It'll be held in this building here in LA. And I only shared the symposium to say that if there's time to get to it on our outreach subcommittee report, at the next meeting, we will need to consider symposium panel topics. So please, over your holiday break or whenever you so desire, think about topics or ideas which might be of interest to you or are burning issues within your practice that could be helpful topics to present as one of the 4 panel presentations for next year's symposium. And last but not least, as Amy mentioned, you may have seen we have a separate agenda today at 3 o'clock. Just by way of background, in 2017, the State Bar Board of Trustees engaged in a governance and public interest task force, which they are required to do every 3 years by statute. That task force, combined with the fact that the bar was, quote unquote, separating, becoming a regulatory agency and not a unified bar, this task force studied all the committees and commissions that exist amongst the State Bar to determine which ones are truly a disciplinary and regulatory function. COPRAC was reviewed relatively early on and determined that because of their ability to advise the Board of Trustees with respect to rules of professional conduct and other ethics issues, as well as drafting rules of professional conduct, which is a responsibility that resides with the board before a rule proposal goes to the State Bar, to the Supreme Court for final publication, as well as our work in ethics opinions, helping to advise lawyers about proper ethical conduct, that the function of this committee remains a disciplinary function and will remain with the bar. That was not the conclusion for the majority of the committees and commissions, and took roughly 2 years to get through the review of all these committees and commissions. And all that to say is a determination was made at the board meeting in September that the mandatory fee arbitration committee would be sunset in June of next year. And they do a variety of tasks, but as part of the directive to sunset the mandatory fee arbitration committee, two of the tasks in which they do, one of which is drafting arbitration advisories, would be transitioned to COPRAC, because we write ethics opinions and it's a similar function. And the other important task that mandatory fee arbitration committee does is draft sample fee agreements. And so today at 3 o'clock, a few members of that committee will be joining us, and they will introduce themselves. We will introduce ourselves, just give a general description of what we do and what they do, so we can get an understanding of each other's work. And then they have two work products that they're working on. One is updating the sample fee agreements. Specifically, I can think that they would want to add language with respect to what to do when you receive a flat fee in advance. They could come up with some language in a sample form. And we're not going to do that today, but they may ask us for your opinions about what to discuss and what to highlight with respect to that rule. And then they're also updating the arbitration advisories, which had been published prior to the new rules taking effect. And to the extent that any of those arbitration advisories language needs to be updated to reflect the new rule language, they will be undertaking that process as well. And they may have some questions about how to do that with respect to certain rules or issues in which they're unable to resolve it themselves. So in a nutshell, that's what we expect this afternoon's meeting to be about. I would say it's probably half and half. I haven't seen them. I haven't seen the material that they'll be presenting, and I expect that they are going to take the lead in terms of asking whatever questions they have to ask. But I did say that we would be open, helpful, and provide comments. We're not going to be drafting on the fly, I wouldn't think. But to the extent that they have questions or concerns that they're unable to resolve on their own, I think we're best suited to guide them with respect to those questions and issues. So it's my understanding that this is the only time this meeting will take place. When it comes time, then after the mandatory fee arbitration committee sunsets in June of next year, if my date is correct, I believe it's June of next year. Thereafter, we will begin assuming some of their responsibilities. So they are trying to tie up whatever, I don't want to call them loose ends, but tie up the projects they're currently working on, so that when it comes time for us to take on their responsibilities, it's a clean slate and we'll be moving forward. So there will be a directive that when we look to appoint new members next year, that we seek at least one, if not two, individuals with fee arbitration background. Will it be someone that's currently on the fee arbitration committee? I don't know. I don't think so, but I'm sure anyone's able to apply. Personally, someone who has that experience, I think, would benefit this committee in a nice transition period to help who's done it before and can kind of teach COPRAC as to what their practices are. But in terms of, no, John and Jane have been identified to join us next year, that has not taken place. But it is true that when it comes time to appoint new members next year, similar to how we seek public members, we will be seeking people with fee arbitration experience. So another thing that was resolved at the Board of Trustees meeting was with respect to committees generally, such as committees are not to meet on Saturdays unless they can provide a compelling reason why. There's large overhead costs. We've discussed this ourselves over the years when it's come up. but the board has actually taken note of that and made reference to it. The other thing that the board has done is said that all committees are to default to a size of 7 unless it can be justified for a larger roster. And so with that in mind, I wouldn't expect that we would be adding people. But the fact that we are combining 2 disciplines, I think compels or is a compelling reason to state that we need more than 7 folks. But that has not yet been resolved, nor been addressed, nor any even conversations been had yet among staff. But we should be made aware that I don't think we'll be adding persons to the size of our current roster. And any other? Yeah, please. I don't have my roster in front of me. Unfortunately, I should have. I thought it was like the 13th and 14th. I'm just guessing, but we'll share that after the meeting, and it will be a noticed agenda item at the January meeting, and we'll share the topics that have been considered previously. We're not taking up 18, 19. Thank you. So we'll probably try to have this. Yes.
Sorry, Andrew. Didn't mean to interrupt. This is Kendra. I can only hear Andrew talking. I can't hear any of the questions or comments.
So just be sure, everyone, your microphone is on when you make a comment. You can know if your microphone is on by this Christmas-inspired red light. And red means on, and then if you push the button, it's off. And it is helpful to turn it off when you're not speaking. It does, these pick up a lot of background noise.
Thank you.
No problem, Kendra. So it's the 18th and 19th, and we can talk more about the symposium in the weeks to come. Any other questions about this afternoon's meeting or COPRAC assuming some of the fee arbitration committee responsibilities? Okay. Thank you.
Okay, so let's go to the draft opinions, and I think we can talk without, an action, oh yes, we have to approve the action summary. So do I have a motion to approve the action summary? Second? Thank you, okay.
All right, we would substitute, but I think Andrew was not here at the last meeting, so.
You were correct.
Yeah. Oh, that's true too. Okay, so I need a different, I guess,
You
no,
just got
Andrew can't second it because he wasn't here.
Oh, could I have a different second? I'll second it.
Okay.
great.
All right, Amy,
Yeah, yes.
Stephen Bundy,
Yes.
Kendra Basner,
Yes.
David Carr. Yes. Eric Deitz.
Yes.
Justin Fields. Matt Hodel.
No,
No.
are you voting to approve the agenda summary from last?
So you abstained then. Toby and Linder. Adam Koss. Amber Lee. Dina Roche. Teresa Schmid. Richard Solomon. Steven Sparta.
Yes.
Marshall Whitney.
Abstain. I wasn't here.
Thank you.
Okay. All right, so let's take the 2 opinions that have public comments, that were out and have public comments. The first, let's see, 12005, the advice, lawyer seeking advice, both from outside and in-house counsel about a potential mistake. And the one comment that we have is on page 41. And I'm the lead on that, so I'll summarize and provide my thoughts, and then we can all discuss it. Essentially, what Professor Zittrain is saying here is that there is already a conflict at the moment that the attorney thinks they may have made a mistake. And our opinion says that there's a sort of little space where you think you might have made a mistake, but you're not sure, and you need to get some guidance on it. And at that point, there's not a conflict. You don't have to. I mean, if we concluded with him that there was a conflict at this point, a lot follows from that, obviously. I mean, this is not, and that notion of whether or not there's a conflict at that moment is certainly not something that the committee breezed through. We talked about it. This is for the purpose of people who weren't present for our discussions of this opinion. So it's certainly something that we talked about at length. From that disagreement, he goes on to say that that our entire opinion vis-a-vis the in-house counsel has to be wrong, because our entire opinion well, I don't know that he says the whole thing has to be wrong, but the fundamental conclusion that an in-house lawyer can advise on whether or not a mistake has been made similar to an outside counsel is wrong, and there's an imputation issue that has to be addressed, because he believes that there's already a conflict at that point. So my view is that he just disagrees with our analysis and conclusion, and there's nothing. This is not the kind of comment or suggestion that you can make a small change. This is a fundamental. This is kind of the point of the opinion. And that if my perspective is we've laid out persuasively, to my mind at least, the rationale and the advantages of this approach, and he relies heavily on the Stanley v. Richmond case, which says that there's a conflict when there's a significant risk that the lawyer's representation may be materially limited. And it seems to me that there's not a basis to say that the lawyer's representation is materially limited at the point at which they think they may have made a mistake but don't know that they have. So I'm inclined not to make any changes based on Professor Zitron's comment, and happy to hear any other reactions.
Well, I'm on the subcommittee, so I'll weigh in. I think what you said is accurate. I mean, I think it boils down to the fact that he doesn't agree with sort of a fundamental premise of the opinion, and that there is that window, and in the course of that window, you can go seek advice, and the act of seeking advice is not a conflict. I think he's saying there's any possibility there was an error, you already have a conflict, and therefore, if you go to in-house counsel, that creates another conflict for that particular lawyer because there's imputation of the existing conflict. I think he just disagrees, but that's not the view of the majority of the committee when it was put together, and it's gone out for public comment, I think, is it 2 or 3 times now, Andrew? Maybe it's 2, but we only have 1 comment now, but we had a lot of comments in the past. And so I'm not inclined to change it, and it really would, as Amy said, not be a matter of tweaking something. It would be really redoing the entire opinion.
Any other comments?
I think Richard's, I agree that the opinion is sound as it is, but I think what Richard is looking at is what I view as the old law on conflicts in 3-310, which essentially says potential conflicts and all their infinite possibility are treated exactly the same as actual conflicts. My sense of things is that new Rule 1.7 changes that and substitutes the material limitation analysis. So to sort of say, well, potential, actual, same thing, that maybe that was true before November, but I don't think it's true now with new Rule 1.7. So I think Richard's critique is, what's the word, obsolete at this point, would be my characterization. So I think the opinion is sound.
And that, I think that kind of gets to Amy's point, right? When you said, I don't know that the facts at the point in time create a significant risk of a material limitation. And I agree with that. You could say there's a potential conflict. If there was a possibility of an error, then in a sense there was, could be a potential conflict. But I think you're right.
Well, and that's one of the problems with the old rule was that, it sort of glibly said potential conflict without really any limitation. I mean, how do you can't sort of corral that concept. But I think, as I said, I think that's now changed.
I also think if you think about the practical consequences of what he's saying, you can't before you find out whether you've made an error, you're supposed to make a disclosure. I mean, it's. I don't think it's client friendly. I don't think it's client centric. It leads to so that is, if we concluded that that's what ethics law and rules required, then it would be whether it's impractical or not. But I think there's a sort of practical support for our conclusion as well.
Well, and it's not really informed either. I mean, if the reason the lawyer is getting the advice from the other lawyers because they need to better understand the situation, to run to the client and say, hey, I may really have done something bad, but I'm not really sure yet, and I'll get back to you, to your point, I mean, how does that help the client? The lawyer should understand the situation and then make the disclosures that are necessary to the extent they're necessary.
Well, you would have to formally make a motion to so direct that take place.
So, is there a motion to send 12-0005 as currently drafted with no changes to the board for approval? I need a motion to do that. Thank you.
Okay.
I would like the record to reflect that Matthew Hodel made an affirmative second on this motion. No response needed.
You know what happens every once in a while. We're actually approved.
For all you new people, we'll talk about it at lunch.
All right, take a vote. Amy Bomsey? Yes. Stephen Bundy?
Yes.
Kendra Basner?
Yes.
David Carr?
Yes.
Eric Deitz?
Yes.
Justin Fields? Matt Hodel?
Yes.
Toby and Linder? Adam Koss? Amber Lee? Dina Roche? Teresa Schmid? Richard Solomon? Stephen Sparta? Marshall Whitney? Thank you.
That deserves a round of applause.
That does.
And Amber, you need to tell Mary right away.
Yeah, it's her. It's her
hers.
baby.
It's hers.
Yeah. Yeah. Well,
Well, you
see
see?
that 12?
We don't have enough time to talk about it.
Okay, so moving on to, what are we on to? Our other opinion that's out, which is, not that we're not doing, sorry, we are not doing, talking about attorney website, but that's not out for public comment anyway.
Back from
I'm getting myself confused, but settling before withdrawing, which is, and we have only one comment on that as well, which is from the Orange County Bar Ethics Committee. Okay, so I think that's me as well. Yes, okay. All right, so Orange County is complimentary. They say that, they were one of the parties that submitted comments on the last go-round, and they say that that we thoughtfully considered their comments, and we did, and we made some of their suggestions last time, and then they have some new ones. And so they have 3 comments. The first one is they note that we talk about misrepresentations on page 5 of the opinion, and then on page 6 we use the word misapprehension, and they're wondering if we're using those synonymously. or if there's anything we're trying to indicate by that. The second point they make is that they'd like further analysis of the conclusion that we reached, that it's okay to settle even accepting money. And number 3, they want us they're suggesting that we add more facts around around the question of whether the attorneys, hold on, how do I describe this? They're saying that the question of whether or not you can settle, or whether there's, information that you have that the other side should have, and how that limits you, it would be helpful to have more facts that helped understand our conclusion that in this situation the attorney could settle. All right, so now that I've kind of inarticulately summarized their three objection or comments, I'm going to just give you my thoughts on them. The first one, when I read it, I thought, oh yeah, that's not good. Misapprehension is not what we mean. We don't mean the subjective, view of the other side, that we mean misrepresentation. But I think when you go actually look at what we say, it's very clear what we're saying. We're saying, because we say that in the context, we're talking about if the lawyer has concealed something, then the resulting misapprehension would require the attorney to fix that problem before settling. So the only thought I had is, should we add to that sentence which is the last sentence in the paragraph at the top of page 50, attorney may be ethically prohibited from settling the case before withdrawing unless attorney corrects any resulting misapprehension of facts caused by concealment of the information, which actually, and I'm not sure that that's perfect, but I think it actually would be a helpful fix to qualify the, well, I don't know, maybe resulting misapprehension is enough.
Resulting doesn't do it.
Yeah, I think maybe it does. So I guess my reaction is, if you read the whole paragraph, it's very clear that misapprehension is as a result of things that the lawyer has done, and not just the fact that the other side has some misapprehension that they came to on their own. No, we're not. At least not. That's not my recommendation. And then, in terms of whether we should provide more analysis of whether one can take money or not, I mean, we could, I suppose, but I think we've kind of said, I'm just not inclined to do that. I'm not sure what we would say, and I think we've said that we don't find anything that would prevent an attorney from settling under these circumstances, and the reason for that, that the client would be prejudiced if the attorney just left them in the lurch, and so I wouldn't be inclined to add anything. And then, yes?
I just have to, on that.
Yeah?
There's a negotiation. Sorry, this is a total aside, but I think it might be relevant here. It's not going to happen very often, but I remember in a negotiation book I used to teach from, there was a wonderful story. This is totally a far field, but nonetheless. Theodore Roosevelt's campaign had made up a whole bunch of sort of Theodore Roosevelt for president postcards. And then they discovered, to their chagrin, right, that the photograph was owned by someone else and copyrighted, right? So they called and they said, we have a wonderful opportunity for you. And the guy says, well, I might be willing to pay $2,000. And it seems to me that's sort of the situation we're in a way, right? If you haven't made if you aren't relying on some factual representation, and the other side has reason. It's hard. That's a very hard thing to please, right? It's a very unusual case. I don't think we can really rule it out. That's, and that's, so it's sort of just to reinforce your point, that I think it's a mistake to try and those cases will be very rare, I think.
Yeah, I mean, I just think we give a lot of guidance. This opinion is a contribution to the profession, and it gives guidance, and maybe it doesn't give all the guidance, but I think the Orange County Bar Association could do an opinion that focuses very narrowly on that issue if they want. But I'm not sure. I haven't thought enough to think about what more we would possibly be able to say. I mean, I don't think we found any authority one way or the other. But I just, again, like, there's probably always more you can say on many topics. But I think the opinion is there isn't a gaping hole or anything that needs to be filled.
Yeah, I think you're right in the sense that I don't know how much more there would be to find that's definitive. My recollection of this issue within the opinion is that we actually didn't broach it originally, and then some of the public comment, multiple public comment. Yeah, but I think it was a couple people said, hey, it would really make this opinion helpful if you answered the question of whether there can be any money involved. And so we decided to do it, and we talked about it, and, people can debate it. But as a practical matter, I don't think we're going to find a lot of other authority or anything like that. I think it's just one of these issues, and some people will think it's right, and some people will argue that, maybe that goes too far.
Okay. And then this last thing that I had such a hard time describing, I guess I don't want to be too defensive of our opinions and not take suggestions, but I feel like what they say is, is the fact in your fact statement that there's been protracted discovery intended to mean that everyone's got, the other side has had an opportunity to inquire into the case? And I think that's exactly right. That's what we intended. It appears that they understand that. They want us to answer specific questions, like what if it was a verified, I think that, was it a verified complaint? Would that make a difference? I mean, again, I just feel like these are other questions that could be dealt with, but I don't think there's a hole in our opinion. I think what we've said is pretty straightforward. If you, the attorney with the newly discovered meritless claim, have not done anything to cause the other side to have a misapprehension about its value, and they want to settle, you can ethically do that. So that's my thoughts.
Just to comment on the first point, I agree. I mean, I think they say, is this what you meant? And that is exactly what we meant. Although the statement, they say, for example, in the statement of facts, attorney's conclusion that the case lacked merit arose after protracted discovery. I think the facts actually say during. So during the course of protracted discovery in the case, attorney learns that the uncontroverted evidence refutes the client's claims. My only thought or comment was, if it's not clear, we could add some, attorney learns through information disclosed in that process that the uncontroverted evidence refutes the client's claims. I don't know if it's necessary, but what they are asking us, what they're saying, did you mean this, is exactly right. So, if it helps to add a word or two to make it clear that, he learned this fact during that discovery process. If it's a discovery process, then obviously the other side has access to that information.
Okay. Are there any other comments on Drew's point or Robert?
I want to go back to the first comment where my sense was they were worried about some sort of subjective standard using the word misapprehension.
as somebody who would defend somebody that might be charged with that, a more objective standard would be helpful if we could come up with one, because my sense is that what we're saying is if an attorney has learned of information that he or she withheld, then they have to clear up a misapprehension if they're going to continue with settlement discussions. Isn't the simple way you clear that up to disclose the withheld information? Isn't that what we're telling people?
No, I think so the missing word in what you said is if the attorney has wrongfully withheld.
Right.
Right? So, if that's true, yes, and that is what we're saying, you can't settle without making that disclosure.
Yeah, because the sentence says, here, for example, if attorney's conclusion lacks merit, was based on information wrongfully concealed, I might say if he or she wants to pursue negotiations, they have to disclose the wrongfully concealed information. It doesn't get into the state of mind of the recipient. It's just a thought.
I had actually a similar one. I mean, I think Marshall's right. That sentence specifically in the example is referring to concealment. The paragraph starts out saying it can be by affirmative misrepresentation or a concealment, but the example is concealment. And I put concealment question marks, sort of the same thing. You know, unless the attorney corrects any resulting concealment of facts, which is sort of the same thing you're saying. It can't be concealed any longer, right?
Personally, I read it the way Amy's reading it, but if there's somebody out there that's going to find an ambiguity in it, we might consider being very direct about it and say, this is what you do.
I think we are saying that is what you do. You have to correct the, but I get what you're saying, Marshall, which is why are we using the word misapprehension, which goes to the state of mind of the other side? Why aren't we sticking with they have to correct, they have to disclose what's been concealed or correct what's been misstated?
I don't think it's a huge issue,
Right.
but somebody raised it, and it could be reasonably resolved by being that direct. It's not something that may warrant rewriting an opinion or making a correction, but it's something to consider.
But the disclosure, again, would then be subject to that Rule 1.6 of that. I mean, the beginning of the paragraph deals with that, but then I think we would have to, again, tie that concept in or at least reference the fact that you can't just disclose. If disclosing that information relates to a client confidential or information you learned from.
Well, that's true.
Yeah,
Yeah,
so
that's
that's
a separate
problematic. That's
Well,
why.
but all we're saying is that you can't settle unless you do that. We're not saying you have to do that. You can't fit every concept into every sentence. I mean, I don't. Well, but anyway, and also I don't think does that change anything, Dina? We're already saying the lawyer has to correct the misapprehension, which means disclose something.
Well, just playing devil's advocate, I mean, I get the point. It doesn't trouble me a whole lot, just because I think in context, if you talk about the concealment, what misapprehension it would exist? It would exist only because there were facts that were not revealed. And so how else could you correct a resulting misapprehension than having those facts now known? So, I mean, I think that's kind of implied if you read it in context. Not that someone couldn't say, oh, this is some subjective standard, but I think you'd have a pretty strong argument if you read it in context. That what this is basically saying is if there was a concealment of a material fact, you can't settle when someone is operating under some understanding that doesn't have the benefit of that. So.
Okay. So, is there anyone else who thinks?
I just have a quick question for clarification, I guess. So, the concealment at issue is something that you learned in the course of discovery that seems to contradict what you thought was going to be like really good evidence for your client. And then if you learn that, if you had no part in creating this fact that was not known before, you don't have any obligation to reveal anything, and you can just settle even though the case is no longer meritorious. Does that make sense?
I didn't quite follow it.
Okay. um, the information wrongfully concealed from the opposing side. The act of wrongfully concealing, you're saying, would have to be done by the attorney.
Oh, yes. I mean, well, the attorney, the client. I mean, the point is that the other side doesn't know something that they're legally entitled to know because it's been asked in discovery or because there's been a misrepresentation, an affirmative misrepresentation.
So,
But if a fact is revealed in the course of discovery that, as the comment points out, was available to both sides, then you don't have any obligation to correct it. You just, I mean, and if the other side doesn't catch on,
Right.
then you can settle, and you're not violating any ethical rules.
That's what we're saying, yes.
but that's not the concealment scenario. Because
Right, no, I get that.
That's a scenario where all the universe of information is available to everyone, including the other side. They don't tumble to something you don't have the obligation to, or they misunderstand what the actual information that's there. You don't have to correct that. But the back end of the opinion, when it's talking about concealment, is not talking about that. It's talking about sort of other scenarios where you might be settling when you know the case has no merit. And if it's because of its concealment, whether your client did it or whether you, the lawyer, did it, it doesn't mean you can necessarily disclose that because of the confidentiality issue. But as far
But
as
if you're gonna
settling the
settle-
case, knowing that they are settling under based on an absence of facts that they're entitled to, as Amy said, then you can't do that, is what the opinion's saying. Does that answer your question?
Great. Okay. So anyone else have any thoughts on the misapprehension issue?
Just quickly, does it change anything to change it to what Marshall was saying instead of using the word misapprehension? Because it seems problematic to think about the other side's state of mind. What if they don't what if they think you're lying to them? And they don't believe your misrepresentation to them? You have to correct it then? It just doesn't seem to change much if you make that quick, instead of resulting, or attorney corrects the misstatement or wrongfully concealed information, I mean,
Right.
to make it consistent. Because I do think there's a footnote in there, right, for 10, that talks about the confidential information and
Yeah.
you can't
Good.
disclose.
That's a good point. Yeah.
I think I'm in favor of changing that word too.
Misapprehension?
Yeah.
Okay, good.
I would
Okay.
agree.
That feels like there's a bunch of people who feel that way.
I mean, it's almost, sorry to jump in, but I think the sentence could end before withdrawing. You could put a period there, and then, I don't know if this corrects it, but pull up the concept from footnote 10 to be the last sentence, because isn't that... Doesn't that concept about when an attorney cannot ethically settle the case as present, isn't that the flip side of the coin that we're concluding the paragraph with?
Yeah, but I think we should tell we should say what the attorney would need to do in order to put him or herself in a position of being able to
I
settle.
agree. I think it's helpful to
Yeah.
give guidance.
Yeah. Otherwise, you're stuck. Marshall, you were suggesting what was the language you were suggesting?
Well, I don't think I was married to particular words, but something to the effect that the attorney should disclose the withheld information.
Or correct the affirmative. Let's just follow our own language. Or correct the prior material misrepresentation. That is the language we use at the beginning of this paragraph. It's a lot of words.
Misrepresentation plus concealment,
Well,
just going to do it?
Yeah, See what she's doing up there? It's a lot of words. That's what. That's.
How
the-
about
the-
you say, how about you say it, this attorney just corrects the, and just say the misrepresentation or concealment?
That's fine.
Yeah.
But no, we want to keep before, just, go ahead. And then,
So just say corrects, like, the should comes out.
and then take out any resulting misapprehension of facts before
Before.
stays.
Should be in.
Before stays, yeah.
Yeah.
And I wonder why we say participating in negotiating a settlement, as opposed to just saying negotiating a settlement.
Negotiating, it's cleaner.
Too many words.
Yeah. Okay.
What do you say, Professor?
Good point.
I say shorter is better.
Always, always.
I say I
Okay.
was a math major, I can't write.
Okay, nice.
Strunk and white.
There we
omit
go.
Needless words.
Okay, does anyone have any comments on Orange County's other 2 points, that we should flesh out some more facts, or that we should provide more discussion and analysis of your right to why it's ethically proper for a lawyer to settle for more than a release? Floor is open. Okay, no? In that case, is there a motion to submit this opinion as modified today, 14-003, to the Board of Trustees for publication?
So moved.
I don't know. She didn't stop this. Drew can't do that either.
Sorry.
Because Drew's the, what do you call him?
Advisor.
Advisor, so he.
My vote
like a
doesn't
ghost.
count anymore.
I move to send this to the Board of Trustees.
Thank you.
Thank you, Dina. And Eric Deeds.
All right. Okay. Here we go. Amy Bomsey.
Yes.
Stephen Bundy. Kendra Basner.
Yes.
David Carr.
Yes.
Eric Dietz. Justin Fields. Matt Hodel. Toby and Linder. Adam Koss. Amber Lee.
Yes.
Dina Roche.
Yes.
Teresa Schmid. Richard Solomon. Stephen Sparta. Marshall Whitney.
Yes.
Thank you.
Yay.
Two.
We're making progress.
Yes.
2 in 1 hour.
I know.
That's unheard of.
Yeah. But these are redrafts, so don't get too proud of ourselves. Let's go to 16-003, ancillary business.
Can we just talk about 12-003 really quickly? And not the substance, but
Oh,
it's kind of wallowing.
of course. No, it's okay. I'm happy to.
I mean, we
Which
could.
one is that? Is
I
that
can-
the-
I'm
the,
happy.
Attorney directory and
Well,
website.
Andrew, can I just talk to you about
Please.
that offline?
Oh, sure.
I
Is there
mean-
development?
Yes.
Okay.
Yeah, I mean, I have a plan. So
Great.
let me proceed with my plan. Thanks. All right, so ancillary business. Steve, take it away.
All right.
Page number.
Where is the page?
It came
wasn't- It
separately.
came in late,
Oh, right,
and so
right.
Mimi circulated it
Oh, I don't.
in parallel, but not as part. Well, this isn't changed that much from, I'll just quickly hit the highlights. I tried to figure out a better way to deal with the issue that came up last time, that we aren't opining on what is actually the money question, which is what constitutes the practice of law. And just one minor change in footnote 2 to explain that we're not just ignoring the question, but that we just don't talk about that stuff. And then there's a later footnote that picks up that point. so that at another place where I think a reasonable reader might wonder why we're not actually talking about what constitutes the I wanted very much to address the kind of concern that David raised last time about somebody sort of trying to have it both ways, right? So the lawyer who is marketing themselves as a lawyer, but actually selling something different. And you know, I do think that at some level that ultimately boils down to a question of fact about whether the lawyer has made the kinds of disclosures they have to make. But it seemed to me that one way that you could make it clear, and also takes us a little more in the direction of the ABA, is to say, all right, it's not just enough to say I'm not a lawyer, right? But to also say, guess what? The benefits of having a lawyer, like attorney-client privilege, are not available to you. So that's been added at a couple of different places in the opinion. And as I said, it's a little more consistent with the ABA solution, which is basically that you need to let the client know that the protections of the attorney-client relationship don't exist. My own view is that for a sophisticated client, if you say I'm not your lawyer, that's probably all you have to say, right? But for an unsophisticated client, very likely you should have to say more. That's not a complete answer, right? We'll still have attorneys doing ancillary businesses who put their JD credentials up or advertise the business based in part on their expertise in the practice of law. I think that ultimately becomes a question of fact as to whether the lawyer has adequately disclosed in a way that makes it clear that although their credentials may be relevant, right, they're not actually offering lawyers' services. But that's something we could. That's obviously a debatable conclusion. So those there are. I did a little tinkering around. I think we had some discussion at the meeting at lines 245 to 250 of the red line. We'd had some discussion about the question of what distinctness meant, and I did a little editing to try and make it a little clearer how distinctness works as a separate principle. So that's what I've got. Now, David has some concerns, and I think he should express them, and I'm happy to respond to them. But the gist of his concern, as I understand it, is that there is this case law, and there are certainly ethics opinions, including the great 1995 141, which is the opinion that Mark Tuft and Jim Kerr put together many years ago, that says basically, if you're functioning as a fiduciary in a non-law business, you are fully subject to the ethics rules, full stop. And that, of course, is where I think that's what led the drafters of the new rules to think that they couldn't do a Rule 5.7 solution here in California. And this opinion, if this opinion is doing anything, it's taking on that, right? By saying, well, really, none of those cases, none of those opinions actually stand for the proposition, because on the facts, the lawyers were either they were either practicing two different professions out of the same hip pocket, right, without any disclosure, or worse, in many of the cases, they were actually doing things that involved essentially getting their business going on the basis of trust and confidence generated in legal profession setting. So the argument then is, okay, those, it's clear it made sense for them to say in those cases, fiduciary rules apply. It does not make sense to extend those cases to a situation where somebody is, for example, set up a separate company on the professional fiduciary rules, with lawyers and non-lawyers be acting as licensed professional fiduciaries who explain that we're not lawyers in this context, or I should say, we're not providing legal services, and who say that any attorney-client privilege isn't available, right? Now the question is, are they invariably subject to discipline, right? Invariably subject to regulation under the professional rules? The answer, it seems to me, should be no, but that's the big thing in this opinion, is whether that's right. So that's, David, you may have more you want to say, or I may not have misstated your position. I may have not stated your position clearly.
No, I think you stated it very well, and I think, thinking about this, 1995, 141, obviously, things have changed since 1995. And to the extent this opinion, I think, I see this opinion as making sort of a, we're essentially making new authority, new policy here.
Right.
And going against this traditional view, a view that I dare say, my guess is that when this goes out for public comment, I'm guessing the Office of Chief Trial Counsel will weigh in against this idea, given their very traditional view of the practice of law. And to some degree, that disciplinary context kind of shapes my questions in terms of whether this is really where we want the law to go, because I think there's no doubt we're advocating a position here that is different than what we obviously we disclaim that prior opinion to some degree in this opinion. So we're very much setting a direction that the Rules Revision Commission decided not to go in by not approving 5.7.
I don't know that they didn't think as hard about it as we did. I should say I've had conversations with the authors of that famous opinion where I quite pushed on this analysis, right? And both of them actually thought this analysis made sense. So I'm not, it's not, I think it's, and in fact, Jim provided a number of helpful cases. So I don't think we're pushing quite as hard against the grain as would appear. I also don't think, and I don't think it was Mark, it wasn't Mark who did the 5.7 analysis. It was Jeff Bush, who I deeply admire, but I think he just decided this is more complicated than we want to work through. I don't think it was represented in deep-seated view for what it's worth. My sense is that it wasn't a firm rejection of 5.7. It was just, we can deal with it on the basis of the law that we have. We have a lot of other things to get through. So I think of myself as having worked to find a constructive advance based on existing law.
And I think to me, the linchpin of this idea is that there's a public policy reason why we shouldn't impose the rules of profession in all these different contexts. And I think you make the case very well for why we shouldn't. I mean, the opposing view would be, well, why, what's the harm in not imposing professional, and what does the public lose? This would be the Office of Chief Trial Counsel's argument, that, well, is there really a compelling public policy reason why we shouldn't impose rules of professional conduct on lawyers conducting these ancillary businesses? Now, that'll be the pushback, I think, from them. So I'd be interested to see what their opinion is.
I will too. I think we're going to get some interesting feedback on this opinion.
Okay, I want to make sure to get other people in on the
Right,
conversation if
yeah.
people have thoughts on this issue.
Right.
Or other issues about this opinion.
I have two quick comments on something unrelated, but just in the opinion itself, just really quickly. On page 6, line 202 of the red line, you're talking about, in this paragraph, about the effectiveness of measures taken. You say, including the clarity, and you've added and detail of the measures taken. And I just wondered, and I wasn't at the last meeting, I'll say as well, but what does that mean, the detail of the measures taken?
I guess I had in mind that it's one thing to say, I'm not your lawyer, I'm not providing legal services. It's another thing to say, I'm not your lawyer, I'm not providing legal services, and none of the protections of the lawyer-client. You know, one is a little more detailed than the other.
Right, or so sort of the thoroughness, or, I mean, I don't disagree with the concept, I
Yeah.
just didn't.
Yeah,
okay.
that's what I was trying to
Okay.
capture. And I'm not wedded to that language at all.
Yeah, I guess my reaction is that clarity is enough, right? That's what you're trying to achieve.
Gone, friendly amendment.
Yeah, actually,
Just take it right out.
Not that we need it, but I guess the other thing too is the measures aren't just the disclosure, right? And so that's what threw me a little bit. Like some of it is the separatedness and everything else, and I was thinking, like, how does detail? Anyway, it's beside the point.
I don't know what I was thinking.
No, I'm sure you were thinking something that I just didn't understand. My only other comment was over on page 7, this section 245 to 250. And again, I'm not wed to this one way or another, but you're talking about the relationship. I guess you're talking about where you might even have the services in the same matter, and there could be some situation where you could still have sufficient distinctiveness. You say the relationship between the two types of services in terms of, and you have kind of a laundry list here, and my only question or thought was, did we want to add that point that you just made in that section we were talking about? So it would be in terms of organizational structure, designated responsibilities, personnel, compensation, and related issues, and the clarity of the, disclosures or clarifying measures and the sophistication of the client. I mean, I don't know if we need to have it there, but you seem to add to try and be more inclusive, so maybe it just muddles it. I mean, I guess the sophistication of the client was the one I was thinking of.
But I think this is about structure, right?
Okay.
Kind of. This is like, how are you going to set it up? Like, is it the same matter, different? Or do you have different offices? As opposed to the sort of things you say at the outset. I don't know. That's just my reaction.
Yeah, well, actually, you're right, because it's in terms of organizational structure, designated responsibilities, personnel, compensation, and related issues. Okay. That's it.
So I have no comments. I think this is in superb shape. I think the changes that you Steve did a great job incorporating our comments from last meeting. But I really do want to, I mean, is there anyone else who wants to have any further discussion about anything in this opinion?
Just when I was reading through the last sentence in the digest, maybe it's just my slowness. The last clause, the rules remain applicable to the lawyer's separate practice of law and will govern the lawyer's dealings with the non-legal entity. So I wasn't totally sure what the second clause meant in terms of the lawyer's dealings with the non-legal entity, and maybe I'm just not what exactly does that mean? The lawyer's deal.
Right, I don't think it's the best language. So let's think
Yeah.
about what would be an improvement. I'm not quite sure, and what I'm trying to capture is the set of discussions at the end which talk about, when do you have to make a conflict disclosure, or when do you have to comply with Rule 300, and so forth and so on. The idea being that those would be obligations that would not be obligations of the non-legal business. Those would be obligations. That's what I'm trying to capture. Now, I'm not quite sure what the best phrasing. That's what that language is trying to capture. But I've never been happy with that language, so I'm open to a suggestion for improvement.
Do you need? So you're trying, basically, in one clause to address everything that you deal with in part 4,
We
right?
could put a period after.
Could we just omit it? The second clause, is that gonna change?
I don't think that. I think we can say that, or separate practice of law. We could say insofar as it involves any dealings with. That would be another way to do it, right? To set practice of law insofar as it involves dealings with.
The non-legal entity.
Yeah. Does that capture our idea?
Lawyers' dealings with the non-legal entity. What does that mean?
Well, we got lawyer-client business. Let's just look at this. We got.
Oh, like you mean the solicitation rule?
Yep. Solicitation, conflict, and lawyer-client business transactions. I think that's the piece we're.
Right, I get that. So the solicitation, it's relevant because that rule will apply to how the lawyer deals with the non-legal entity. I get that. The conflicts, well, maybe we should be more just be more specific that the rules apply to the lawyers. Well, we could say including. We could just separate govern the lawyer.
How much say how a separate practice of law including any dealings with? Does that do it?
Well, do we need to say including? I mean, that's all we're talking about, really, right? I mean, it's true, of course, that the lawyer is governed by the rules when they're practicing law, but we don't need to say that.
Right.
So could we just say the rules remain applicable to the lawyer's
dealings with the non-legal entity?
Including such as limits on solicitation, conflicts of interest. I mean, that would make it really blatant.
So how would you read it?
I would say the rules will remain applicable to the lawyer's dealings with the non-legal entity, such as rules pertaining to solicitation, conflicts of interest. I mean, I think that's it, because we conclude that there is no lawyer-client business transaction.
There is if the lawyer is recommending the business.
Okay, so we want to list all three then. Okay. Solicitation, conflicts of interest, and business transactions.
I like the however though. Sorry. Applicable lawyers dealings with an entity. Including, how about? Yeah.
I mean, I don't think it's clumsy, but at least it tells you what portion of the opinion it's summarizing.
I was going to say, let's say, no, I think we have to say this though. It's not quite the lawyer's dealings, is it? The practice of law point got lost, right?
Well, yeah, we took it out because
Hold on.
yeah. So maybe you want that back in.
I was going to say.
Can I suggest some language?
Yeah, yeah.
Maybe approach it from the other end, where the operation of the non-legal entity has a close, is connected with the operation of law practice in areas like solicitation, conflicts, because it's only where there's some kind of, dare I say, nexus or connection between the operation of the non-legal entity and the lawyer's practice of law.
I don't think that's the connection we're capturing.
No?
I don't think so. I think what we're saying is there has to be no connection in the functional sense.
Okay.
Right? So otherwise we haven't got a true non-legal entity. It's got to be distinct, and it's got to have said we're not part of the lawyer's practice of law in order to get to this situation. So
Okay.
how about, I would say, how about this? How about the rules governing, and say where it says the rules will, say the rules governing the lawyer's separate practice of law, comma, will, however, remain applicable to the lawyer's dealings with a non-legal entity.
We began.
I know. Well, I mean, it actually, really, that's what we're capturing. We're
Right.
capturing the fact that the lawyer is in the practice of law.
We just don't love the word dealings, I think.
Yeah.
I think that's the problematical word.
Right.
What does it mean, dealings?
It's not quite that. So the three things we're talking about are limits on how the entity can solicit.
Why don't we just say remain applicable?
To what?
Right.
Remain applicable? Well, that's easy.
That's why. Right, it's okay. The rule, there's got to be a draft position.
Well, it's these three things. It's everything in number 4. It's, so the dealings are the non-legal entity soliciting business for the lawyer. And the lawyer referring the client to the non-legal business.
How about this?
Would it be too cumbersome to include specific reference examples to just that human actions?
So then it would say, so.
In parentheses, e.g.
Yeah. I was going to say rules governing the lawyer's separate practice of law, comma, including rules pertaining to solicitation, conflicts of interest, and business transactions.
That's better, I think.
Right.
I think that does that help, David? What dealings means?
Yeah, I think it clarifies what sorts of dealings we're talking about.
Right.
Good.
So, if I understand it, you're wanting to address this scenario where there is a distinction in the business and the practice of law, but when the lawyer's wearing the lawyer cap, then they need to comply with the rules.
That's exactly right.
Okay, well, it doesn't quite say
So they
that.
can't have this entity out there carrying the solicitation flag for them, because they're not allowed to have somebody do that for them.
Yeah.
And they can't, if they do have dealings with the entity where they're like referring and getting a fee, right, then that would trigger the conflict rules, and also might trigger the lawyer-client business transaction.
Do you think that last sentence is sufficiently confined to acts involving the practice of law vis-a-vis the client or the non-legal entity?
I think in context it's pretty clear.
Okay.
I mean, I think that what this says is, look, this doesn't mean that the fact that what we're trying to really say is that the fact that the business has escaped from the world of being regulated doesn't mean that the lawyer has escaped.
Right.
So they can't use the non-legal entities to circumvent those duties.
Or it's just not their practice is not an ethics-free zone.
Right.
That's the basic point.
But if the lawyer is both in the non-legal entity and in a law firm,
Mhm.
have we given guidance in the digest that when the lawyer thinks he's acting on behalf of the entity, he may actually or she have ethical responsibilities because they're broaching the practice of law?
How do you read that?
Well, I could be misreading it, but it seems to me there will be scenarios where the lawyer practice and the non-legal practice involve the same human being. And if that same person thinks they're operating in the context of the non-legal entity, but actually providing legal advice and guidance, is there a risk that we haven't addressed that in this sentence?
I'm not, Marshall, I'm wondering if we could add another sentence. Well, not another sentence, 3 words at the end. To the lawyer's dealings with the non-legal entity in the course of the lawyer's practice.
That's kind of what I'm getting at.
Does that do it?
Some qualifier on what dealings mean.
Yeah, in the course of the lawyer's practice. That then doesn't take back
Right.
the promise of if you really have set yourself free, you're back in bondage because of this last sentence.
Yeah.
Right. That's a little awkward,
It is, but I mean,
but it's accurate, I think.
you could play with that and tighten it up now if you want.
David, does that meet your concern now? Is that better?
Well, the kind of language I'm thinking about would be something like except where the lawyer's operation of the non-legal entity will have an impact or have a impact on the lawyer's practice. And that's maybe not phrasing it. But some aspect of how the lawyer operates the non-legal entity has a connection or an impact on the lawyer's law practice. That's probably not much.
Well, we could
difference.
say this. We could say it's awkward again. We could say the lawyer's relation. Yeah. Well, it's not perfect. I agree, but I'm not sure how much better we can make it.
I mean, I always think that you have to, the digest, it's a digest, right? You have to, the opinion is what it says, and
Yeah.
So it's always hard to,
Right, to capture every
Condense
word
everything.
and to capture every word, and especially since this stuff is old law.
Yeah.
Everything we've done in that part of the opinion is already in
It's just a
1995,
summary.
141,
Yeah.
although there are some tweaks, but basically this is all good, solid, existing law.
What we're really talking about is his dealings with the entity in his capacity as a lawyer, right?
That's
Right.
exactly what we're trying to capture.
is that better than in the course of the lawyer's practice?
Well, you could say it will, however, remain applicable to the lawyer's dealings with the non-legal entity in his capacity as a lawyer or something like that.
Well,
I don't, maybe
no, I
that's
don't
not good
think
language,
Yeah,
but that's
it's
the
not.
concept.
That's
right?
the concept
Yeah.
of it.
No, change it back.
Please go back there, yeah.
Yeah, I mean,
I'm
if
satisfied with that.
he's acting as a lawyer,
It's definitely better than what David identified as a problem earlier. It's much clearer than about what we're trying to say. And I think that at this point, the issue for everyone would be, is the disjunction between this and what we actually say in the opinion so great that this is sort of not accurate, but I think it is pretty accurate now. It wasn't so accurate before.
Yeah, definitely an improvement. And although we hope and that people will read the whole opinion, the truth is that many people will probably just read the digest. Many lawyer people, I mean.
Yep, yep, no, you're right.
Well,
I mean, the only question I have is, I don't know if we've ever done this, but, I mean, when I write legal briefs, when I have a summary, I cite to the portions of the argument. Yeah, well, no, I say, see part 1, see part 2. And I'm just wondering, here, there's a real clear, like, break. Like, there's basically 2 parts to this opinion. The first part is about separation and disclaiming, and the second part is just kind of I don't know what to say, like a buffet of covering some various rules.
So you want to put in like a head note? Yeah. See.
I'm just wondering. I mean, I don't want to introduce some new
I've never seen
practice that
in
we've
an
never
opinion.
done before, and I don't think it's necessary. I think this is good. Do you want to see if you can come up with anything better over lunch, or are you satisfied?
I'm satisfied with the committee is satisfied.
Okay.
I have a question.
can we see it?
On line 288 of the red line, I think you added the word last. I think there's a word missing.
Sorry.
Yeah.
Oh, no, I intended last to be the subject of that sentence.
Okay.
If the people don't,
I mean,
we could just say.
I've been reading it for like 5 minutes, and I did think
We
that
could
was
just
a
say-
possibility, but that's
That's
that's a little too sophisticated, possibly.
Well, we
for
can
people
just
in
say.
Congress.
I could strike that whole sentence as a practical matter.
No,
Or we could just say.
I think this will likely, you don't need last.
Let's take the last out.
Yeah.
Close enough.
I mean,
Then, I don't know, this is a big point, and I agree, there's no rule that's going to require it, but should we be more affirmative, since we are kind of creating a new environment here? Should we, I'm looking at the same paragraph, should we be more affirmative about the type of disclosures that the lawyer should make? And I know that's difficult because there's no rule that says so, but such clarifying measures are more likely to be effective if they spell out. I mean, should we just be more proscriptive about what we need to do?
my own feeling is we shouldn't try to.
Not must, but, I mean, just be more affirmative, like this is, you really need to disclose to the, more specific about what information should be provided to the client when you are gonna step away from your obligations under the rules.
Well,
of
I guess I don't, this is, it's a fair point, and I thought about it, and the conclusion that I came to was that I didn't want to try and set a bright line. Once, because it seemed to me that the answer could in fact differ from client to client. We're not writing a rule here in a sense, we're sort of setting up a common law standard, and it seemed to me that there would be situations where you darn well would want to have that language about there's no attorney-client privilege here, but there might be other situations where it wouldn't be necessary, and I wouldn't want somebody where you wouldn't want the disclaimers to fail because that language wasn't in there. You're dealing with somebody, face it, I think a lot of these situations are going to be situations where people are represented by counsel. If the document that somebody represented by counsel says no attorney-client relationship, no services, that ought to be enough.
Unless, yeah.
And in the
I'm less
consumer
worried about
situation,
those. Exactly.
in the consumer situation, I think ordinarily you probably ought to say more.
And that's where I'm coming from.
Right.
So,
But I
there's-
think
And I don't think, I want to add 2 paragraphs to
Right.
distinguish between those two, and I take your point, and I think you do have that concept here where you're a sophisticated client and or you're represented by counsel. I understand that point. I'm more concerned about the unsophisticated client. Who knows what new innovative businesses might be developing over the next 5 or 10 years, where lawyers just out of law school are seeking to retain consumer clients. I think that's how you describe them. That's what I was
so
concerned about.
just, Andrew, there's also the same concept is said earlier also at 204 to 207, and I'm just wondering if I mean it's equally non-bright line, but
And I would be more than happy, Andrew, there to say, if the client is not sophisticated, right?
right.
The customer is not sophisticated. I would say, we could say it will be important.
Yes.
Right?
Yeah.
How about that?
Yes.
No, it's at line 202, 204, excuse me.
So instead of depending on their sophistication.
And just say, if the customer is not sophisticated.
Yeah, that's an improvement.
That does it. I think that
Yeah.
pretty much gets, that's pretty close to prescriptive.
Yeah.
All right.
My only other question with that and the attorney-client privilege is, I won't say it's the most important, but it's obvious and a big one. I couldn't think of others that might be expected by a consumer client, but if, to the extent that there might be another to list in there, I would think that we consider, I'm not saying we have to list every obligation, but the big ones, I don't have a suggestion. I can't think of another one. I mean,
being regulated by the rules of professional conduct that apply to attorneys or something. I mean,
that's a little too far. Yeah, but I mean, so here's my concern just generally. I'm a non-lawyer. I see that you have attorney at law on your business cards, and you're also doing a different business. and I come to retain you for that other business, but I'm unsophisticated, and I think you're also my lawyer. What are things that you know as the lawyer that would protect and apply to me if we were an attorney-client relationship that I might not otherwise be aware of as the non-lawyer client that arguably should be disclosed and disclaimed? And I haven't thought about it. There may not be any additional ones. I'm just suggesting, to the extent that anyone can think of it over lunch or might want to share or have had this experience in your own practices, just to be able to add it as a parenthetical phrase could be helpful.
Yeah, I mean, I share your concern about that concept, especially with the trustee role, where you have a lot of people that could be the role of a trustee, not necessarily in an active legal proceeding if you're administering a trust or something like that, and so maybe the person is not represented, the parties aren't represented by a lawyer or law firm, and they're just dealing with a person as a trustee who may also be a lawyer, right, and having that distinction in their mind, and a person who's not a sophisticated legal person may think, oh, this person's going to be a better trustee because they're also a lawyer, and sort of understanding that, well, what does it mean that they're also a lawyer, and you may think that there's a benefit to that. Kind of what you were talking about.
The halo of trust.
The halo of trust, but to the extent that you say, I'm in this role, I'm, like you said, what are the things that make it different? I have obviously obligations as a fiduciary in this role, but I'm not being governed by the rules of professional conduct that attorneys are governed by, and would that really mean anything to that unsophisticated person? But
Right, that's kind of the worst disclosure, right? I mean, in the sense that...
Right, but it's, again, what are the things, I think that's what you're getting at, like, besides attorney-client privilege, what are other things that could make it so that this person understands that, to dispel the halo effect, or maybe there's nothing you really can do to, dispel it.
There's some part of the halo effect you can't, I think,
Yeah.
David and I were talking this morning, I think there's a piece of the halo effect you can't get rid of.
Yeah.
If somebody has a JD or has practiced law for 20 years, they probably deserve to get some halo effect out of that.
You're not, the thing that you are still getting, that people might be going to you because you have a JD, is you have certain analytical skills. And those aren't, you still have those skills.
Or life experience that could be highly relevant. I mean, the fact that you've been a states and trusts attorney for 10 years or 15 years could be really relevant to your qualities as a professional fiduciary too. But the critical thing, I think, is, I think that it's a fair question, Andrew's question, as to what other, the way that Model Rule 5.7 frames it is that you have to make clear that the protections associated with associated, right? It just says the protections, without specifying what they are.
Right. So, and I take fault for this.
How about including but not limited to?
I posed the question about listing the duties and obligations that might otherwise apply if it was an attorney-client relationship, which aren't going to apply. But just, if I were in this situation as a lawyer, I mean, something I would say, and this might be overdoing it, say, although I'm an attorney, I'm not your lawyer with respect to this service. Should any legal issues arise, you're going to have to seek a separate person to represent you on those issues, and you're not going to benefit from the attorney-client privilege and the duty of confidentiality when you work with me, because we're not in a formal attorney-client relationship. Is that overdoing it? Maybe. But I think that is sufficient waving the hands and saying, hey, buddy, I'm a lawyer, but I'm not your lawyer, and let's proceed together, because we all know that. That's protecting the client and the lawyer in that example. Is that overdoing it? I'm open to being criticized that it is, but that's just something that's in my mind.
But I kind of like that type of disclaimer and maybe a little more detail on the type of disclosure that needs to be. I think that would be appropriate in the opinion and useful. And I think,
well, we do say at 290, 291, that it may be relevant whether the customer had or was advised to obtain separate legal counsel in the matter.
Yeah, but this is right. But this is before the situation I'm thinking of is before the need for a lawyer arises. And I also like where you identified, Steve, or Amy redirected me to it. It's an earlier point in the opinion, which I think is helpful. this more introductory portion of the opinion. And I'm not raising this to slow things down, other than the fact and also noticing there's no conclusion stated yet. So if there's any hope to voting this out right now, we do need a conclusion paragraph. But I just wanted to share the concept that I think a sentence or two, in addition to the list you have about.
Do we have to have a substantive conclusion? As opposed to a conclusion?
Thus concludes the above.
Yeah, what? I mean, I honestly,
Why
I
do you,
do
I
think
hate
it drives me
conclusions. I
crazy.
know how I end briefs? For the foregoing reasons.
Right. I mean,
Nobody's reading at that point, right?
all we're gonna do with that is, we already have a digest. Yeah,
I've seen you guys do that. I just looked exactly like the
but,
conclusion.
but I don't, but then why do that?
I don't know. That's just the way I've always seen it.
Okay.
Well,
Because there's
people
value,
look to the conclusion sometimes.
Yeah.
I mean,
there's,
Well, but if they don't see it, then they gotta go to the.
there's value, and sometimes there's value in repetition, and
I was gonna say, maybe it's more like,
See above.
yeah.
So I just a practical question. So let's imagine that this is published and that I am a lawyer and I provide social work, psychological counseling. I also provide and/or medical consulting. And I come to you, Stephen, and I say, the bio I have in my business says that I'm a California lawyer. But would you tell me you better read this opinion and you better make sure you have disclaimers and you explain consequences? Was that clear?
I guess what I'm saying is, I don't think that this is quite the same as, say, a conflict disclosure, right? What we're really doing is implementing well, it's a really, all you guys are raising a really good question, and there's something here that has been nagging at the edge of my consciousness, which is, what do we say in our opinions, for example, about websites? What do we say about what you have to say on a website if you want to avoid inadvertently forming a lawyer-client relationship? How strong and how detailed are the kind? I mean, that's more like what I think we're doing.
Well, these scenarios are good because they present the caution that everybody needs to be aware of. You need to be cautious because you are a law firm. You're now going to provide fiduciary services. You're going to provide e-discovery services. Right. I said, whoa. Yeah. There's no question. That part's easy. Because people are likely to be misled that you might be providing legal services.
Right.
But this is a great opinion. It's a great subject. But it seems that you could take plenty of sentences out of this opinion and be in a quandary about the hypothetical that I posed. Which is, this is my bio. It says what I'm a member of the California Bar, went to this law school. I am a psychologist, social worker, medical consultant.
Right.
I don't have a law practice in this office.
Right.
I mean, that's just a fact. I don't say that I'm just wondering whether I really would have to read this opinion merely because I listed my credentials.
Where, Matt? Like on your website, in your bio?
Do I need it? Just because I tell people I'm a lawyer and I'm providing services where there's going to be a personal relationship, one of trust. Trust every consultant. I have to make a disclaimer?
Well, I guess I'm trying to understand.
Well, we don't opine on that question.
Well,
right? In part because we do cite the ABA's list.
Right?
That's and that's where, of course, you got the social work piece, right? Because the ABA says that social work might be
it says economic consultant, medical consultant,
Right,
environmental consultant. I get the environmental consultant part,
right.
but a medical consultant, what's a medical? I just was wondering if it's possible to have I know you, yeah, I didn't like when people ever did this on the opinion I was working on. I've already done all this, I've already thought all this, but do you think it's deserving to have a scenario where you could describe it in this opinion, where anyone who would read it go, yes, you don't need any disclaimers in that? Because we now have
You
put
mean
out
other
there.
than the ones we go quickly by, which are restaurant and dry cleaner?
Yeah, I saw that. Any lawyer who's got a dry cleaning service.
You know,
But-
I thought about that. I have thought about that. And the result of that thinking is kind of in the opinion. And what it says essentially is it's a tricky thing to decide in any particular case whether something is so related to the practice of law that it triggers this set of obligations, right? The practice of law is itself a moving target, right? And context also matters. So as I looked at this list, I couldn't say. So I think what we say at the end is, the broader list may provide useful guidance to lawyers seeking to determine, right, whether it is potentially subject to the rules, and hence when these disclaimers are required. I mean, we could go further and say, but I think we'll end up with the angels dancing on the head of a pin, trying to figure out what's in and what's out.
One other thing to add is, we say the rules aren't going to apply. However, there is new rule 8.4, which applies to a lawyer. It's not limited to acting as a lawyer.
Right,
And
but that I think we've already acknowledged.
It's going to apply it's going to apply. You can't disclaim that rule. The fact that you can't disclaim that rule.
It's basically maybe I should have 8.4 in there, but if they're it's like we have 6106 in there. You can't disclaim 6106.
Right.
Right. I mean, if you're engaged in moral turpitude, right, you can be disciplined for that. Right. No matter.
Even
what.
though it's outside the practice of law, I agree.
Totally.
Yes.
And that's a starting place. We're talking about. And I assume that pretty much overlaps with 8.4, right?
Yeah, I mean, it captures some of those statutory concepts. 8.4C says it's professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentation, engage in conduct that is prejudicial to the administration of justice, or B, commit a criminal act that reflects adversely on the lawyer's honesty,
We should
trustworthiness.
add 8.4. Right to the up front by 6106.
I think that would be helpful.
I think that would be
right.
very desirable. Here's what I think makes sense, Amy, and you tell me if you disagree. I'm itching to not be thinking about this anymore and to have it out the door. But I recognize that there are a couple of things to think about. One is certainly adding the reference to 8.4. And another is seeing if we can find some language that addresses concerns about sort of how comprehensive the disclosure should be and what they should include, that goes a little bit further in the direction of meeting Andrew's concern as echoed by others.
Yep.
And I am more than happy to try and do that in the lunch hour with whoever would like to participate, and then see if we have a votable product. If we don't, we don't. But if we can get a votable product that we can vote on this afternoon, I would love that. But
Yeah,
make sense?
I think that seems fine. Yeah, that would be great. But if you feel like you can't, there's nothing wrong with pushing it over to January if you don't have
No,
Okay,
okay,
all
I don't
right,
want
there is
that.
something wrong with that.
I don't
Fine,
want that. I don't
anyways.
want that unless the committee
right.
wants that.
All right,
All
well,
right?
no, but we can't spend another like 45 minutes discussing it after lunch, so if.
I got that.
Yeah, okay, great. Okay. Okay, so what I was thinking is that we, if people have the stamina, we turn to Marshall's outline of the duty to of confidentiality versus the duty to communicate. And we talk about that, and then we have a lunch break. And I think lunch break should maybe be 45 minutes instead of an hour today, just because of the fact that we've got a break at 3. Is everyone okay with both of those proposals? Okay. Maybe we have a 3-minute stretch and bio break.
Hey, Andrew.
It might have circulated.
Well,
Yeah, maybe it's on here. Well, read mine. You don't have a version? It's over there. Yeah.
Thanks.
It is. Oh, it is. It's at 3 o'clock. It's going to start. Yeah. You know, like, and that's you know, I have to remember how I some people like urban kids will find LA.
Discussion about can you settle discovery, everyone's discovery is sincere, right? And it's like, but be mindful of the I mean, I get handles, I'm not talking broad. Yeah, you're right, those are actually apples and apples for perjury.
I have this brilliant paralegal who has a way of putting things that is unintelligible. And it's a big deal. I'm concluding a $3 million settlement, and she's got it all. It's got to go out today. I love her. She's been with me forever, but every once in a while her brain shorts out, and I do not understand what the hell she's saying.
All right, let's come back.
Can I borrow this?
Yes.
I'm gonna try and get this drafting.
All right. Okay, we're gonna get started and talk about Marshall's outline for an exciting new opinion. So Marshall, take it away.
Thank you. It's pretty rough in general. When we started this, we made the bold pronouncement that there wasn't any authority for the conflict and tension between confidentiality and the duty to communicate with the client, and that's really not the case. And actually, by way of just a little bit of background, when I started putting together for our committee's discussion the factual scenario, it looked remarkably similar to the scenario that was in an earlier opinion that COPRAC wrote in 2003, which is the 2003 opinion number 163. So we started and retooled the factual statement. It appears pretty clear that it's not terribly debatable anymore that the duty of confidentiality is paramount unless there is going to be, under our rules, some serious threat of criminal activity that could result in bodily harm. We don't have any other exceptions. And so when you look at the New Jersey analysis, which is discussed in this memo, that's helpful and probably worthy of comment, but it's not pertinent to our rule 1.6. So what I have here is just the very crude statement of facts, which will be what I would like to receive some input on in terms of tweaking the facts so that we could raise important issues. Steve and I and Adam and Toby have talked about the possibility of putting a greater emphasis on prospective waivers, whether or not those would be enforceable and useful. The Shepard-Mullen case that came down in August kind of punted somewhat on that and gave some guidance on it. So this is really at a very early stage, and if people have read it, it would be useful to talk about. One of the ways to tweak this, which would make it more interesting, is to change what the confidential information was, to change whether there are, and the impact that confidential information would have on the client. In our scenario, the CEO is spitefully withholding beneficial information to the employer. One of the ways you could tweak this would be for the employer trying to get away with a fraud when in fact the CEO disclosed the information, so there was no fraud. And the client really has unclean hands by trying to perpetrate a fraud, but at the end of the day, there was no direct fraud because there was full disclosure, and it would be very helpful to the employer company's case to know these facts in defense, but the prospective client has made it very clear for reasons and motives that maybe aren't all that beneficial, or beneficent rather, that they don't want this information disclosed. So there's a lot of different ways of tweaking why the information's being withheld, what the information is. In the end of the day, I'm not 100% sure In fact, I'm doubtful that any of those tweaks would really change the ultimate conclusions we reach. So that's kind of where this opinion is. It's in a very nascent stage. Any input on things that you would like to see in it? While I'm listening to some of the discussion we've had today, I keep thinking about 1.6. Can we throw some answers to some of the unanswered questions in the earlier opinion in this one? It's possible. So I don't know, it came in late, whether people have any input on what they would like to see included. Otherwise, if not, what we can do is go back and beef up the facts a little bit and then start putting in an analysis.
Marshall, I had thought that, I thought that one issue you all were thinking about addressing was when the information comes from a prospective client rather than an actual client.
Right.
And so are you still contemplating doing that at least as one of the scenarios?
Yes. Yeah. I think 1.18, I think, is the one on prospective clients. I think it's not, I think it needs to be discussed. I don't think any of the conclusions are going to change.
I don't either. But when I was reading and thinking about this, I kept thinking, how do we square flat with any of this? I mean,
well, I remember when I read flat for the first time, I was struck by what they didn't do, what they didn't tell the lawyer he should have done. And flat doesn't really address the question at all of what do you tell your existing client. And that's why the prospective client scenario, Steve's talked about that, may be the most useful, because we can talk about where flat should have gone. Because I think flat should ultimately go to the conclusion that the lawyer who received this information from the client, in that case, I'm going to file a lawsuit against your client, and you dismiss the client and don't tell them about statute of limitations, you're okay. But should you then go to your existing client and say you're about to get sued? And I think the answer is no. I think that's the answer. And nobody's directly concluded that, but I think our opinion back in 2003 was pretty close.
I guess my question is, to some extent, doesn't flat sort of say that the duties that you owe the prospective client are lesser than the duties you owe the existing client? At least some duties?
I think that's a fair conclusion to reach from flat, because you're not communicating to the prospective client legal advice they should have because of the division of loyalty between prospective client and existing client. So the division of loyalty issue has to be addressed in this opinion.
Right. But you're thinking that the answer is your loyalty to a prospective client. What Flat said is that you can't possibly be required to place a duty of loyalty to the prospective on the level of the duty of loyalty to your existing client because, well, I can't remember why they said that, but I remember that that's the conclusion. But you're saying that the same analysis wouldn't apply to the duty of confidentiality.
Well, yes, and what's we have talked about, and what I've always found troubling, is our opinion back in 2003 just makes a flat statement that confidentiality trumps all, essentially, without really going into why. Because you've got the three competing duties: the duty to communicate, the duty of loyalty, which is very significant, and then the duty of confidentiality. And what you're getting at is really, in some ways, the more interesting tension, the tension between the duty of loyalty and the duty of competent representation and disclosure of confidences. It gets into all of that, and it wouldn't hurt us to kind of elaborate kind of the pecking order and try to come up with some rational explanation, which I haven't done the research for, as to why confidentiality, at least in California, short of committing a crime, should trump everything.
I think the prospective client setting is very.
Can you get closer? I can't hear you,
Yes,
Steve.
I think the prospective client piece is very important, and I think you are both right in identifying flat as important to understand. I actually had a situation involving this issue with a prospective client in my practice, and it was very interesting because it seemed to me that the way flat reads, right? You can create a non-frivolous argument for either solution, right? And it might be, given that, it seems to me it makes a lot of sense to try and clarify what the right answer is,
right?
Rather than leave it completely up to creative lawyers and their clients.
Right, but now we have a new rule on prospective clients, which also changes.
Which
the
also
landscape.
changes things, and I think will help too. I
Right.
agree with that.
Help or hurt.
You
Well,
know,
I mean, it'll help to clarify.
Yes.
what I've seen before, in just kind of a practical sense, without a lot of ethical analysis, is lawyers say, well, I can't represent you, I have a conflict, you need to immediately go consult with another lawyer because you might have statute of limitations problems. Does that then violate what we're talking about in flat? You're not telling them they have statute of limitations problem, but you're telling them to go seek counsel. You're giving legal advice that could be adverse to your existing claim.
To your current client.
Yeah.
Well, if we really want to get into flat, I think I've always thought that Justice Kinnaird had the better of the argument, right? That having sat down with this person, having not issued any disclaimers, right, of any kind, and having just sat down and created the set of expectations that would normally require you to advise about the statute of limitations problem, you don't get to walk away from that because you have a conflict.
Right.
Right? I mean, I think that Flat was simply wrong about that. So there's a separate question there, Marshall, as to whether we want to try to chip away at that piece, right? And at least say, even though you can't be sued for malpractice, there's still a good argument that you should at least be required to hold up your hand and say, you may want to talk to another lawyer right away.
Yeah. Well, what I'm hearing from Amy and you, and what I think makes some sense, is to put more of an emphasis on the factual pattern that the CEO was a prospective client, not
right.
an existing.
And I've mentioned this earlier, and I'll mention it again. I think that to have an alternative factual pattern, my reaction to the CEO fact pattern is that the lawyer for the corporation has all kinds of reasons to want to, as a matter of competence, if they're going to take on the officer, even in unrelated matters, right? They have all kinds of reasons to want to get the kinds of planning waivers and so forth and so on, or scope of limitation. If you tell me anything about the business, I can't keep it from my corporate client. Probably that's a competence thing you should be saying, right?
In my scenario, but
I was saying just to finish the thought, in the situation where somebody wanders in off the street,
yeah,
right, and they have, which is the scenario that that came up in my practice, you can't do that. There's no way you can sort of deal with that in advance.
Because you don't know what's going to come out of their mouth.
You don't know what's going to come out of their mouth. You don't know that they have anything to do. They don't have anything to do with your client.
One of the twists to this hypothesis is that how do you use the information? because I haven't seen anything yet on that. That doesn't mean it's not out there. But you know now where to look. And as Steve points out, you now know your key witness to cross-examine is there. The client of the moment. I think I always look at a prospective client as having a limited engagement. So they are your client if they're sharing confidences with you, at least to the extent of that consultation. So now what do? Are you forever tainted to represent the entity because you've acquired information that's given you a rifle shot to take on the CEO who just consulted with you? It creates a unseemly situation for that lawyer. And so dealing with that, I think, would be useful too.
I found the fact pattern a little odd and convoluted. I mean, normally you would expect that you would learn the individual client would disclose something that made him culpable that he didn't want shared for obvious reasons. I may be wrong, and there may be really good reasons to do it this way, but to me it was a little counterintuitive that he actually had exculpatory information that didn't harm him in any way for it to be known and helped his former employer, but he had a sort of psychological reason not to want it disclosed. I was a little surprised that you went that direction.
And I'm trying to remember why I twisted it. The original hypothetical was more in line with what you're talking about and went right into opinion 163. So I'm open to that because the more we can write an opinion that would resonate with day-to-day likely experiences, the better. And mine is very unique. So I wasn't married to it at all.
Yeah, I kind of agree with Amy's comments on that. Just I think it raises some interesting issues, but like factually, I mean, this idea that he's a corporate defense attorney and then he's going to give advice on a marital dissolution proceeding, like I thought that seemed kind of
Contrived.
That's a good word. In that context, and then I was also sort of wondering, I mean, if it was true that he had represented the corporation and then the CEO of the corporation he's representing came to the lawyer, I mean, it's a good opportunity to discuss, like, I think what Steve said, well, what are the things you say from the beginning of, like, before you say anything, you know, are you analyzing, like, well, why are you coming to me? And before you're actually creating, like, that prospective client, attorney-client relationship or the sharing of information, it's like there would be some disclosure, I would think, that you would want to make about that, or you'd obviously be concerned about potential conflicts. I mean, right away, I think that would be something you would think you would be concerned about, right, before even meeting with that person.
Right.
So maybe it's a good way to have that discussion about, you know, conflicts. I don't know what, you know, but that's just something that kind of was raised to me. It's sort of like before they start telling you all that information, how are you handling that initial meeting and transaction with the prospective client? You know, like vetting conflicts first, and how do you vet those before you have a substantive conversation about which would lead to that disclosure?
So you're talking about some sort of Mirandizing your prospective client, saying information you give to me, essentially, you know, I may or may not be able to represent you.
No, but I'm just saying, I mean, this seems like one of those situations. It's not the random person off the street, which I think that's a situation that maybe is more amenable to the conversation, because this is something, if you're representing the corporation in this action, and if the CEO says, I want to talk to you about my own legal problems, I think right away, I think most people would say to themselves, well, you'd want to say to yourself, well, what's the nature of the scope? Is there already dispute? This person's been terminated for these reasons as part of the fact pattern here. So if there was a former CEO that's been terminated, would you even meet with that person? Would you say, I represent the corporation, and, you know,
well,
I'm not saying Mirandizing them, but I'm saying before this disclosure took place, there would be things, and maybe that's, but I think the prospective client coming off the street where you have, you know, you've done a basic conflicts check and you don't think that there's any conflicts based on your own system, what are the parties or the disputes, and then it becomes clear that there's information that you didn't know about that raises a conflict with the current client. That's
when they start giving you more depth, then you go, well,
right,
oh my gosh,
right,
no problem.
Right, and that's something you couldn't necessarily, like, you had proper protocols to protect against that initially, and you couldn't necessarily anticipate that, but how do you handle that? I mean,
Well, I think,
that's maybe not what,
I think it's something to discuss.
yeah.
You know, when you're talking about a prospective client interview, before you agree to represent them, most lawyers know to say, look, you're sharing non-confidential information with me at this point so we can do our conflicts analysis. That's sort of de rigueur. But in this situation, if you know that this is a former CEO of a corporation, I think what you're getting at, and I think it makes sense, is if I'm representing you and you tell me stuff about my client, understand that for me to represent you, I have to be free to disclose pertinent information to them. Otherwise, we can't really have this relationship. That's kind of what you're getting at, right? Being able to tell the new client, I have an existing client and I can't have anything you tell me compromise what I'm doing with my existing client.
Yeah, before the interview even
Right.
takes place.
Right.
Say, you know, you may, in the course of this interview, you may tell me information that I find creates a conflict with a present client. And in that instance, I'm not going to be able to help you. And I may, well, I don't know if you can go so far as to say, under 1.18, I'm not sure you can say that, well, I may be required to disclose this to a present client.
No, I don't think you can. I think what you could tell them is, I will not represent you unless we agree that if you tell me something, it has to be prospective, and that gets into this perspective. It's kind of a form of prospective waiver. But this person here, I mean, the way it could be worked out now is you had no clue. In the course of it, he blurts out something, and then maybe following up on what Amy said, he blurts out that he's done something terrible that's going to hurt the company, which is fine. I had it at one point that way. I just tried to depart from what we'd already written.
Yeah.
Which almost caused me to start from scratch and say maybe we shouldn't do this. But I really think I think Steve's instinct was, let's take flat and really kind of address what it didn't address with this opinion, and so we can do that.
I'm just thinking of this right now, but like, what if the person was like a former employee that was actually had been involved in like R&D at this company, but you didn't know that when you're meeting with them because they were coming to talk to you about a specific problem.
That's exactly right.
It's isolated. And then during the course of their discussions about maybe their current employer, they said, well, you know, because I have this job here, and tell you things about which happen to be your current client in this matter, because you wouldn't necessarily, when you're checking for conflicts, say like, where are all the employers that you've worked for? I mean, there's going to be a limit to what you're going to do, and then that way that could come up in a way where you've done a level of due diligence in terms of your, conflicts checks at the beginning, but then this information comes up and it impacts the current matter, and like, how do you handle that information?
Right.
You know?
Yeah, you're representing a lower level employee who's actually in the R&D department that uncovers these problems.
Yeah.
And disclosed them to the company, and the company then sold the product anyway. Yeah, that's a natural twist. I think that's fine. I think it gets out most of the issues. So.
Okay, so Marshall, so we have some at least discussion about adjusting the fact pattern, and I mean, are there other questions that you want to hear from the group? No?
I don't think so. We need to I'll switch the fact pattern around, talk to Stephen, Toby, and Adam, and try to get it worked out.
I mean, I have the experience of I've been asked to help on situations like this where lawyers, particularly who have very narrow fields of representation, their clients are always bumping up against each other.
Mm-hmm.
And so, the one client, the client just picks up the phone and says, hey, we're thinking of buying this. And they're already representing someone who's working on buying the same property, right? I mean, it comes out, it's before you're even like, they have to disclose that information to do the conflicts check. I mean, and then, the question is, do you have to, you obviously have to turn down
number two, but you have to disclose to number one, and you have to suddenly withdraw from number one just because you were poisoned by this one sentence. And I just, when I'm lecturing on this and get that question, everyone's just looking dumbfounded because it seems like insane that that should be the result. But it's it's hard to give clear guidance on a pathway through. And so one thought is, like, that I've thought about is, if you are in that situation where your clients are constantly bumping up against each other, do you do a really broad kind of perspective, like, because of the nature of our practice, we sometimes learn information and, whatever. Either everyone agrees that we're not going to share it, or everyone agrees that we will share it, or whatever. And who knows if something that broad could.
Well, you raise an interesting dilemma. An example would be your partner represents some company that's doing a regular course of business, and it's kind of like one of the COPRAC hypotheticals. Regular course of business with a particular vendor, and the vendor goes to your bankruptcy partner and says, I'm looking for a bankruptcy lawyer. Can you represent me?
Mm-hmm.
All they've disclosed is the subject matter of the representation, but that subject matter in and of itself is horrendously important to your other client.
Right. I think stuff like that would be super helpful for people because it is exactly the kind of stuff that really happens. Okay, cool. Well, let's take a lunch break. Try to come back at 10 after 1.
Thank you.
Thanks, everybody.
Thank you for getting me out early. Appreciate it.
Oh, we'll miss you. Someone over there.
I got it, I think.
Oh, good.
Make sure we get
I think the only way to go here is that, and I think it's probably a good move. Accept that change.
Yeah.
There isn't a good answer.
So maybe there's a.
Oh, come on.
Maybe there's a way to make it
I think there's
something on a current matter.
Come on,
So
that I
relevant
should
to
be
the
able to
current
get
matter
rid of that.
versus relevant to the current client.
Delete, and then accept that change. Now, please accept
throw
that
out
change.
some ideas on how to best avoid these problems too.
Well, and I don't, so what I
All
don't
right,
think
here,
you did,
hold on.
which you seem to get close to,
Accept
I don't
this
think you can
change.
tell as a prospective client.
Okay,
This isn't confidential.
yeah, I think I've got an answer. Do you want to have a look?
Yeah.
I want David and Andrew to look at this too.
Yeah, I'm
But
not sure.
so the first thing is, I'm really embarrassed to have missed 8.4.
That's why we
You're
have
not
a
my
committee.
client.
I know, but this should have come up a long time ago. Applies.
It-
In
There's
addition,
gonna be a
Rule
lot of
8.4
I think-
applies by its own terms even where a lawyer is acting
If you do
appropriately.
the current client that you know
Yeah, I mean, I'm not sure we need the whole thing,
versus
even when a lawyer is not practicing law, right?
Yeah,
what
okay,
happens then, I think
exactly.
that might be
And even when
because
a
this,
lawyer
I mean, from a
is,
you're sitting there and some guy tells you, yeah, you know,
dot, I'm not good at these, dot.
Well, it gets back to what
do you know a bankruptcy lawyer?
it gets
Okay,
back to what Steve was
so-
saying. I don't know that we need to
Not practicing law.
address the existing client other than in passing.
So anyway, so we
Prospective
put that
client is
in.
gonna create most of the
That's, and then I said, but with the exception of Rule 8.4, the rules do not themselves specify when they apply to non-legal services, because the Rule 8.4 says they do.
If you're representing.
And then on the warning point, I think we should just go whole hog. Right? Ordinarily, the lawyer should explain that the particular protections associated with forming an attorney-client relationship, including the attorney-client privilege and the view of confidentiality, will not apply.
They represent a lot of people at odds.
How is that
Same
different from what we used to say?
Well, we used to say that you should only do it if the client was unsophisticated. Now I think
Oh,
we say
we're saying,
More affirmative.
I see.
Pretty much have to do that.
pretty much
Right.
have to do that. Why? It
So,
seems to me
no, I'm just thinking about, I
People
mean,
listing 15 clients they represented.
it's
it's fine. I mean, with a sophisticated client, you don't need to, but there's
no reason not to, right? Yeah.
I'm just thinking Andrew really wanted So you think there's,
a
is it
disclaimer to
clear
your
in the
current
opinion that one of the
client
things
that
you're
says,
obviously
"If I
gonna
learn
say is,
something,
I'm not your
going to
lawyer?
tell you."
Oh, yeah, no attorney-client relationship, right?
Right,
Right.
yeah. So Andrew was asking,
Yeah.
should you say,
At least better than
I'm
if you
not
tell me this and
gonna
and
be
it's bad
able
for my
to give
current
you
client, I'm gonna
legal
tell.
advice?
Or you go to a current client and say, you know, I have a partner that does bankruptcy work and constantly is consulted to see if he can
Well,
take
it
on a
clearly
case.
is,
I
but
can't
Andrew was
disclose to you
thinking,
that I've been
is
consulted.
it
I'm not gonna
obvious?
tell you whether or not and get
So
them
you
to sign
say,
the waiver.
okay, there's no
That's pretty
attorney-client
specific.
relationship being formed.
That might
so
work.
won't be providing you with any legal advice. It won't be confidential
Right.
or privileged.
Right.
I would say, you going
I mean, I'm not
back up
saying,
now?
I'm just.
I was gonna say, we've got it in there, where the customer is
gotta
not
make a phone call,
sophisticated, it
though.
may be relevant whether the customer had or
You might
was
get a bite
advised
to
to
eat.
retain separate legal counsel.
Yeah.
Because it's not the case,
Are you
we
freezing?
don't actually want these people
I had
to
a
say,
suggestion for him during lunch.
I'm advising you there are legal issues here, you should
I'm
get
out
a
of it.
lawyer.
True.
We
Right.
don't want them to say that, or
Well,
we?
we don't want them to
think
say,
I missed
always
it.
have to say that.
Right.
I think we're at,
Right,
yeah.
no, that's true.
so the customer, it may be relevant.
I mean, I'm fine with it.
I think
this
I'm
is
inclined to
such-
leave that the way it is.
Yeah,
I
Okay.
think-
something.
Because we're not locking
And you're
Yeah.
on your.
That we don't
discipline
wanna do
in
that.
anything. I don't think we want to lock
Right, if
people
you're
in.
that one.
That's good.
All right.
Do you want to write a conclusion, or just
No.
cut and paste it? Well, I'm with
But,
you,
yeah,
as
it's
you
a
heard,
bummer.
but
Yeah.
they seem to be uncomfortable with no conclusion.
She did great.
Yeah.
I think I wouldn't have anything to compare it to anyway.
I don't, let's just look at what we did. Let me see. I mean, I hate the idea. I think the problem with drafting conclusions is that then you get into exactly the same crap
The
you got
digest.
into at the digest.
Well, of
Is it
course.
accurate?
I
Does it
think
change
for this
everything?
opinion
This
in
opinion, it would be
particular,
crazy to do
conclusion
that.
is it's
Unhelpful.
counterproductive.
Okay, good,
Yeah.
fine,
All right.
okay.
So we're gonna,
Well, we
we'll
on
see if we
this
can
busy,
push it.
so-
All right. I'll send this back to Mimi. And,
Okay, great.
yeah. Do you
Two of
guys want to talk about the other
Yeah,
stuff?
do you mind doing that for a quick minute?
No, not yet. Sure.
All right, so I didn't bring my notes from that lunch, which is too bad.
Me too.
I was gonna say, yeah, the first thing is what did we just?
I know.
I didn't
I walked out of there. I couldn't remember a damn thing.
Oh, I have notes, but, so what I think it said was, one thing is we're going to identify the opinions that we're going to discuss.
Right.
And we're going to tell the drafting committee, we're discussing this opinion, so it's gotta be in and you gotta, and so people, so maybe it won't be a requirement to always to turn around a new draft every month. That's the main thing. And then the other thing is that you and I, as the advisor, our role is gonna be to push, sort of to force people to get to talk. And I'm gonna say to them, that you have to have a call, like, between each meeting, it has to happen. It's not like, maybe if you want.
And then I think in thinking about what we want to push for next time,
Yes.
I've been hoping to be able to talk about home client, but I think marijuana we should
Yeah.
definitely have a conversation about
And,
marijuana.
and what's,
And
who
I-
is it who's gonna,
Me and Kendra.
okay, right, that's right. Did we communicate that to Kendra yet?
I haven't yet.
Okay, all right, well, I will do that. Okay, so yes, marijuana, and yes, the client rating thing that Andrew's clearly fretting
Yeah.
about.
And then I'm going to prepare a report on the vulnerable client to see if we want to continue it. I'm just not sure.
Depending on the discussion today, I think maybe I can turn around another draft of the litigation funding.
Yeah, you're very close now.
Yeah.
I think it's very, very good.
All right,
And,
so maybe next.
But of those the other one we haven't heard about in a long time is the impaired lawyer opinion.
True.
We haven't
That's
heard about
Eric, isn't it?
It's Eric and
Kendra.
Is it in the list? I see it in the current list. Maybe
That's a
I
good
just
point.
glossed over it.
Yeah, no, I don't recall seeing it either.
Good to see you.
Yeah, there it is.
Oh, it is. Okay.
Yeah, all right. I'll ask Eric. Ask Eric. So that's awful that you have to have that. That's just inhuman.
It's not productive.
Right, I'm sure, exactly. It's
You've been up
useless.
for like 7 or 8
Right,
hours
what's
by the time you
you're,
start.
yeah, exactly. Well, the lucky thing for you is I don't know what we're doing at 3, but I don't think it's gonna be terribly
Yeah.
demanding.
I just don't feel very helpful today.
No, it's okay. I wanna hear about what's been going on with your case and stuff, and how that's been going. Ask Eric about impaired. Kendra.
Your firm's actually involved in our case.
Oh, really?
In a tangential way.
What lawyers?
Throckmorton.
Oh. Is this, who's your client? Can you say who your client is?
Bridge. Strategic Partners.
Oh, I don't actually know about this case.
So, he represents someone who I think of as friend. I mean, he's not a party.
Yeah,
But you guys handled a case where he was affecting a dissolution of a business with his partner that they created.
I see.
He ended up getting bought out.
Okay.
But in that business, which continues, is now suing a business that was created by some relations to him.
Okay. Oh my
Who
gosh.
used to work
Wow.
at the old company.
Wow.
And it's this whole loyalty where these guys worked in the house. They had law degrees. And this is indisputed. We say they did basically almost zero legal work. Most of it was non-lawyer stuff. They say, oh, you were a lawyer all the time, right?
Yeah, we rely on it.
So this company had a sweetheart deal where they created this public agency. They were like, no staff. The agency had no staff. So this private company was like contract staff. So they ran the whole thing.
Okay.
And it was a conduit issue for bonds, public finance bonds, for build a school, do all this kind of stuff, right? And so they had a contract for like 20 plus years, no RFP, nothing ever went out. Then in like 2012, they had this contract where it said like, even after we stop providing services for the issuance of the bonds, we get fees for the life of the bond, no matter what we're doing, right? Like millions of dollars. So we knocked up all this money.
Yeah.
Got this exclusive contract base because they're in. They're like both sides. There's no one in the public entity that is staff, right? So Lockheed comes in 2012 and the state treasurer goes nuts.
Yeah.
It's ripping off the public.
Right.
They do an audit. They introduce a bill that's going to regulate all this stuff.
Yeah.
So then the public entity says, no, we'll enter an agreement with Lockheed. We'll get an independent executive director, and a real board, and all this kind of stuff, and we'll do an RFP. Right? So they do that. And these two guys that have been working at HB, there's all this animosity developing between Throckmorton's client and the other guy, the county attorney, right? So they eventually leave.
Set up another company. Right.
But anyway, John has the father and uncle. Who, and so anyway, he's not a party, but he's clearly going to be, he's coming up on deposition and stuff like that.
Well.
But it's really,
It's
really interesting too, because the public entity aspect. I mean, it's not only got the whole thing of like a lawyer with dual capacities in a entity, where maybe you're doing some legal work, but you're doing a lot of
Right.
I knew this whole thing about the public entity.
Yeah.
How can stuff be caught? If you're basically a public official. While you're wearing your hat as, the program manager for the public entity.
Yeah.
And so the private company can't be telling you stuff about that entity that it's telling you as a lawyer that somehow it's confidential and secret. I mean, it's just, it's way more complicated than that. But
So your client are the people who went off and competed?
Right. And formed the company, and then they won the new contract. And I mean, it's big.
Yeah. suit is like a breach of loyalty.
It's like a, yeah, it's really boiling down to, I mean, they say, it started with a complaint that said, on information and belief, you use and disclose confidential information, all this stuff. But from my perspective, this isn't anything secret. I mean, it's just the way the positions in the litigation are shaping up, even in file pleas. But I mean, there really isn't anything. After a ton of discovery, there's nothing that they disclosed. They can't show that or use. So it's really boiling down to loyalty.
Right.
And then, and this other thing, because they said, well, they must have used it. That's kind of where they're at the end of the day. Like, how could they not if they have the number? We can't show you. We can say, where is it? Show us where they show. What single piece of evidence is there that they ever disclose this to anybody? You can't show disclosure. I think they won't say it, but they probably admit that.
Yeah.
But use, and we're like, where's the use? Where's the use? And none of the stuff that was required to respond to the RFP, you didn't need it. It was all non-confidential information.
What were these your clients? Were they? I mean, isn't there just like a basic breach of fiduciary duty kind of? I don't know, something like that's not lawyer based.
Well, they're alleging breach of contract, and they had some non-compete provisions and different things like that. And those are at issue too. I mean, because of the business and profession code sections that promote, mobility and the ability to practice. So there's limitations on what you can do there. And our position is you're stretching them in a way that is not acceptable. But part of it is that a lot of those contract provisions, they don't really apply. I mean, they don't have any evidence. Like, did our guys actually go out within 6 months? And do,
Right. And so are they seeking rescission?
Disgorgement of profits. It's like an unjust enrichment claim, saying basically if you did something bad, you shouldn't benefit from it. And we either get what we think we can show we would have made if we got the contract, or we get what you made. But here's the other thing. There's a killer case. We just, there's some judgment brief, but there's this new case that came out in the Supreme Court last year too, said with a public contract, you have no expectation. So
they can fire you at any time.
I mean, so they got these, like interference with, economic advantage, perspective, whatever, and it's like, you can't have it.
Yeah.
Because
Interesting.
Because in the public contract, they don't have to give it to anybody.
Interesting.
Interesting. So it's got like a
lot of issues. Yeah. And so you filed your brief, and then have you briefed the reply?
No, that's going to be a nightmare.
How come? Different issues?
Because the two guys have slightly different issues on some facts, because one left earlier than the other, certain, it's just, but anyway, well, right now, the throes of our discovery cutoff's coming up, so we're trying to finish all that up, then we're going to be into experts, and then we're going to trial at the beginning of March.
What court?
After Acosta, Judge Austin.
Never heard of him. Not good.
We had, I forget what her name is. At the very beginning of the case, we had Judge Fannin. She's great. So we were really disappointed.
What happened?
She rotated off, I think, and I can't remember. I don't know if she became chief or if she just, moved to a different section.
Is this a jury trial or a bench trial?
Jury.
Interesting.
Anyway, it's pretty interesting. It's interesting.
Sounds like a good case.
It's nice to look at it from the outside.
I'm sure. I know. I'm sure you're just exhausted and.
Well, no, I just see the stakes. It's like, it's interesting if we.
Yeah. All right, let's get some food. Yeah, I know. You know what? They have no respect. Yeah, it is a conflict. Work. Yeah, no, I mean, it's ridiculous.
This is on explicit disclaimers?
It's both.
Oh, okay.
It's first of all, I'm embarrassed that I hadn't picked up the 8.4 issue.
Well,
But here it is.
you know, it's sort of a pale shadow of the statutory.
Right. I just said, in addition, Rule 8.4 applies by its own terms when a lawyer is not practicing law or in a professional capacity. Okay, then, so then I say, but with the exception of Rule 8.4, the rules don't specify how they apply to non-legal services.
Okay.
And then, coming down here for the disclaimers.
Including but not limited to.
Here's the word, instead I've changed it from, if the customer is not sophisticated, right? Ordinarily, the lawyer should explain, right, that the protections associated with forming an attorney-client relationship, including the attorney-client privilege and the degree of confidentiality, will not apply.
That seems sufficient.
Doesn't that seem broad enough?
That seems broad enough to me. I mean,
yeah. And then I'm going to put it. I changed it down here to conform. Right, and so we say, what is this? Did she take that out? I don't remember taking that out.
Yeah, I can't even read it. The blue strikeout?
Yeah. That's weird. That's strange. I wonder how that happened. Hold on. Let's just see what happens here. Control Z. No? There we go. That's what it's supposed to say. Accordingly, we leave in a distinct from his or her law practice can avoid the application of the rules of professional conduct services if she provides the client with reasonable alert that no legal services are being provided, that no attorney-client relationship has been formed, and that the protections associated with the attorney-client relationship, including the privilege and duty and confidentiality, will not be available.
Okay.
So that's basically a conforming change. And now at this point, what we then are not saying, or which we're leaving flexible, is whether you have to say, and you should consult another lawyer. And the answer, I think, that we'd say that can depend on whether, it probably matters only for unsophisticated clients, and it's it depends kind of thing.
Well, I don't think it's necessarily to include it, though I don't think including it would be harmful.
Well, exactly, but so we have it. We flag it, but we don't say you have to.
Yeah, I think there's a value in not making it too detailed.
Yeah.
And just hitting the concepts without trying to give people a laundry list.
Right.
Of all, here are all the things you need to talk about, because
right.
If you leave something off the list, then people will say, well,
I don't have to talk about it.
Yeah.
All right.
That seems entirely fine to me.
Okay, so that's how we're going to go. I think we're going to send it back, and hopefully we can get it out on that, because I'm not doing a conclusion, because sort of just repeating the digest.
Right.
I think we just dig ourselves a hole.
Yeah, I don't think it's necessary. I mean, the digest is, to me, the more important part.
Right. Okay, so here we go. Let's get this back to Mimi. It's a new way of calculating an hourly rate.
Uh-huh. Right.
What kinds of cases are these failures to appear in? Criminal misdemeanor cases or? Really? So David is cool with these changes.
Oh, good, excellent. Right.
Hopefully we can do it.
Good, good, like the backroom lobbying. Do you want anything? Oh, come on, you're falling asleep and
I know.
it's not gonna help you out.
Well, I can pass 2 cups,
Yeah.
then it starts making me feel.
Yeah, fair enough.
I mean, I could use the caffeine.
I know, but you don't want,
Thank you, then.
Yeah, that would be nice. I know that,
I'll put it up here for now. And when you pick a seat, you can put it down.
I guess I'll grab the seat. shouldn't be, especially if the microphone's on, because it has to have the microphone there. That one's on.
Kendra, are you still there?
We're not online yet, are we?
Not yet, but I'm checking to see if Kendra's still on the line. I guess not.
I'm on. Okay. In response to the comments before the lunch break, I took some time. Andrew and I have talked. David and I have talked. And there are basically three places where the opinion has changed. The first is displayed here at 92 to 94. And at you can see it down to Rule 100. Basically, what it does, you see, is it says we put Rule 8.4 in there to capture Andrew's point, that it applies by its own terms no matter whether you're practicing law or not. So it's obviously not something that you can get out of by establishing that you're not practicing law. And then, so that changes slightly at 97. Then we say that these services can trigger the application of other rules of professional conduct. With the exception of Rule 8.4, the rules do not specify when they apply, right, to non-legal services. That's the first change. Second change is a little further down. It's in the warnings section. Here's the way we've rewritten. Ordinarily, the lawyer should explain that the protections associated with forming an attorney-client relationship, including the attorney-client privilege and the duty of confidentiality, will not apply. So we've just made it, instead of saying that's something you should probably do when the client is unsophisticated, we just said that the general rule should be that. And then stepping down to the 256, right? No, that's not it. No. And here's the third one. This is in the sort of money paragraph describing scenarios 1 and scenario 2, right? What is it that if she provides the customer with reasonable notice that no legal advice or services are being provided, that no attorney-client relationship has been formed, and that the protections associated with the attorney-client relationship, including the privilege and the duty of confidentiality, will not be available. And then such clarifying measures are more likely to be effective if the notice is in writing. So those are the three changes. With respect to the conclusion, I took an informal poll of a few people, and we concluded that the difficulties of drafting a conclusion that would do anything more than the digest does were formidable. That the digest already does about as well as we can do in summarizing in short compass, and that therefore we should leave the conclusion as is. So with that, the question for the committee is whether people feel it's ready to go.
Okay. Anyone have any comment on those changes or, yeah? Andrew and Mimi, are you all comfortable with our conclusion on the conclusion?
Hang on. I'm looking at something. As hopefully that might have
Something to talk about while I'm
Oh.
researching on the background here, but if not, that's okay.
All right. Yeah, we do have something to talk about. So, so we'll do it now. I was planning to vote and then talk about it. But, we, leadership, Steve, Drew, and I, and Andrew got together to just chat about ways in which we could improve things, or, and one of the things that we came to the conclusion was worth trying out, at least as an experiment, is rather than attempting to discuss every opinion, every meeting, and everyone attempting to draft a new version for every meeting, we are going to target 4 or 5 opinions for the next meeting and tell that drafting committee we expect to see a new draft. It's just, and everyone will, and those will be circulated, and we'll expect everyone to have read them and come with comments. So the idea is lessening the load of work for all of you for reading, and making sort of more clear and getting commitments. So if there's a group who says, well, there's just no way we're gonna turn anything around by next meeting, then we'll know that in advance. Rather than right now, there's a sort of, everyone tries to get their opinion turned around, and some do and some don't. And rather than that, we can sort of talk to people about their time commitments and when they genuinely think that they can get a new draft turned around. And and there's a few opinions that we really want to sort of step on the gas with, including the marijuana opinion that really there's a lot of clamor for something from COPRAC on that topic. So that's a change, which hopefully will be useful. And then there's always been this, in addition to the drafting committee, there's always been a person, either the chair or the advisor is sort of like an additional member to each of the subcommittees, and I think what I would like, I want to shift that. That's fine. I mean, that me and Drew, we can act as regular members of the subcommittee and offer, suggestions, et cetera. But the function of that person at this point going forward is really going to be to make sure that the subcommittee is meeting and moving forward with the opinion. So, and I'm really going to expect that, particularly in the months where your opinion is going to be up, that you're getting the lead drafter or lead drafters is getting a draft turned around early enough for the subcommittee to read it and give comments. So just hopefully a way not to increase your burden at all, but to increase sort of the focus and interest of us all in these opinions and get them moving forward with a little more quickness. But this is democracy. So if people have concerns about that approach, you'll feel free to talk about it now or let us know later. Okay, back to you, Ed.
So I found the authority I was looking for, which is the rules of the committee, and it says, format of formal opinions. Each opinion shall set forth. There's 6 requirements. You'll be happy to know you've obtained 5 of the 6, and that is a statement of issue or issues addressed, a concise digest summarizing the rules, conclusions, and reasoning, hypothetical facts of the ethical question presented in a general manner without identification of the requester or any details of the request which would permit such identification, the rules of professional conduct or other authorities relied upon, an analytical discussion of the applicable rules applied to the hypothetical facts, and a conclusion.
We have a
We
conclusion.
have a conclusion.
Oh, what does it say? I thought we didn't have one.
It says,
I apologize. I didn't.
no, it isn't. We're being a little bit cute. But I mean, it doesn't say that it has to summarize.
Doesn't say anything about what has to be in the conclusion.
Well,
And-
sure. I mean,
But what's
any
the-
document you
Andrew,
have is by
listen,
nature
Andrew,
going to
I'm
conclude.
I'm
in
just
some
gonna,
way.
let me put the
I'm-
question.
Sure.
Let me put the question more concisely. What would a conclusion accomplish?
Well, exactly.
No, but that, I think we can argue it fulfills the rule. What's the point of a conclusion here? This is an 11-page opinion that's dense with 12, dense with authority. It makes a complex argument. It deals with a lot of different situations. What are we going to say?
So, same disclaimer that I always give whenever I make a comment. I am not intending to be difficult. All opinions do have a conclusion heading. The rule specifically requests that a conclusion be present. It could take you're right, there are a variety of forms in which a conclusion may be shown. I honestly am not trying to be difficult, but I think to be safe and best practice and not being challenged as though we didn't comply with our own rules, I would advise that we include a conclusion.
Mimi, can you pull up the rule again? Because
Have a heading and some sort of
we
conclusion.
have a heading.
Right.
And I'm also not trying to be difficult, but it seems to me that each of those statements says what the content needs to be. And the last one just says, it does not say anything about the content. And I don't think, if the only reason we're doing this is to comply with the rule, I don't think that I think we've adequately complied. If it said a conclusion summarizing the opinion, I wouldn't think that we had.
Therefore, we conclude that it should be one sentence.
No,
I
it
mean,
couldn't.
It could be.
But it couldn't be because there's no way to.
No, not in this opinion, but I mean, maybe another.
Oh, yeah.
It's not out of, I mean, like, yeah, what I'm trying to, I'm agreeing with you.
I mean, I'm
that-
just thinking.
A
You know,
short
we don't define
conclusion, I just don't see how we do a short conclusion that doesn't make a short substantive conclusion that doesn't make the opinion worse.
Well, my 2 cents. When I write a brief to the court, I state my argument at the beginning, I state it in the points and authorities, and I state it again in the conclusion, because I think there is some value in repetition. I see no reason at all why we can't take what's in the digest and repeat that in the conclusion. I think it meets what I think the rule is trying to get at. It fulfills that requirement. Plus, I think there is value in saying things more than once, as I said before. It may not be elegant in terms of drafting, but in terms of how people actually use these opinions, people like me, people like my clients, press for time, what do? You go to the conclusion. Press for time, what do? You read the digest. I see no reason at all why we can't just essentially repeat what's in the digest in the conclusion.
Essentially or exactly?
Well, even exactly.
I mean, if you.
I defer to the committee, whichever they can. Those are the 2 alternatives. I'm not in favor of trying to rewrite a different conclusion that tries to do something different from the digest. If people think that it makes sense to repeat the digest there, I think the opinion is horrendously long, so I wouldn't personally vote for that. But if other people, I think maybe if we can have a straw vote on that point, that would be helpful.
Yeah.
Aren't we required to have a conclusion?
Well, I guess that's a.
Isn't that part of this discussion to know that? You seem to be a pretty good writer. Steve, it seems to me you can give one more pearl of wisdom in a very smart way.
I'm just I'm looking back now at a couple of these others.
You can do it.
No, wait a second. I'm sure I can. It just feels like a huge waste of time.
I think an 11-page opinion with lots of legal authority that's dense is more reason to have a conclusion, not less, because of what David's saying. I mean, not that anybody in this room would ever do it, but I agree with David that people do sometimes not read long, dense opinions.
Let's go.
Toby.
What's the last thing?
Wait, Matt. Toby.
I'm sorry. It seems to me that you can pull some of the the principles out of here, and then if people want to know what that means, then they have to go back. So for instance, online, you could have a list of those for different sections. On line 109, it says, even when the lawyer or law firm is providing non-legal services that are distinct, I'm sorry, I'm not supposed to be straining my voice, which is a joke, distinct from the lawyer's practice of law, the rules of professional conduct can still apply if they're sufficiently related. I mean, that's a conclusion. That's something you could put in a conclusion, and whoever wants, and then you have a whole discussion. And I think that there are, within each section, you can pull like the overarching and put it there, and then people can go back and get what the need is. And that would be an appropriate conclusion. I agree with Adam. I think with something this dense, that's helpful.
Anyone else? Okay, it seems like, all right, I'm going to have a straw poll, although I feel like we sort of have a sense. But anyway, can I see a show of hands for everyone who thinks that we should add a substantive conclusion?
Done, okay. Next meeting, folks.
All right, all right. Okay, thank you, Steve.
You bet.
And I'm just trying to, I'm sticking with my position that is a conclusion because it says conclusion. Okay, we are going to turn to the opinion on the lawyer departing law firm, which is 55 to 83. All right. Dina, is there anything you want to say to the group about these the changes that you or anyone on your subcommittee want to talk about changes in this new draft?
Yeah, the changes, they're not a lot of significant changes in this draft from the prior draft, although we didn't really, if you recall, have much time to talk about the prior draft. It was kind of at the end of the last session of our last group of meetings, and so the opinion in itself, which I don't necessarily think has been discussed at length really at any point in time, could bear that discussion. I have gotten some comments from Justin. He emailed me some things, and I know Amber has some comments and stuff too related to the opinion, but just overall, obviously it's long. There's a lot of information in there. It definitely, I'm looking for ways to, subject to people's feedback and stuff, sort of condense it, reduce it, streamline it, to make sure that we capture a lot of the important things in here, but not necessarily be duplicative, which I know in parts I think there is that, and that needs to kind of be looked at more carefully, and I think some of my subcommittee members have committed to helping do that. But as a general I would like to get feedback from everybody about whether they think there's anything in there that they don't agree with or seems wrong to them from an ethical perspective, and just general feedback from anyone is welcome and appreciated. So I'll just leave it at that.
Great. So Amber, do you want to start with your feedback?
Well, yes. So in my initial discussions with Dina, I initially started to go through the draft kind of almost doing like line by line editing, and then I thought, no, it's not there, so I'm going to stop. I think just overall, because it does contain so much information, and I think the information that's in there is necessary, because if you're going to do this type of advisory opinion that's different from doing it through hypotheticals, once you start to add certain duties, you kind of have to do all of them, I think. And I know that in my own practice, this is all of the issues that are addressed in Dina's draft come up often, and of late, quite often. So I don't think any part should be cut out, but I think each section can be shorter. Starting with the introduction, I think that the essential point that we want to stress, I think, throughout the opinion is how this has to be client-centric approach. And in the introduction, it sort of takes us a while to say that. So using that as an example, I think that we can do that throughout the opinion. Just kind of state what we think the essential thing is per duty that we're discussing, and then go from there. I can give examples, but I'm not sure if it's worth the committee's time right now. I think that I offered my assistance to Dina in helping to draft the next draft, kind of play around with how much we can cut and keep the essential information necessary. Yeah, there are some, and as I understand, there were some authorities and discussions that were left over from the prior subcommittee. Is that right, Dina?
Before there was an outline, and so I drafted from the outline, and that had a particular structure, which I mostly kept in terms of like the order of things, and conceptually the concepts, and so those.
So we can cut out some of the repetitive ways in which we discuss the same issues. So those are kind of like more, like I said, like a big picture, broader comments that I have. And I think that we would be in a better place to discuss the nitty-gritty once we have a shorter, tighter draft. That's my take.
Just in front here, we often do this thing where we say, we start with the subcommittee and then we open it up, but I'm not I'm going to not do that this time. So I have comments, but I'm going to hold them, and I'm going to ask just generally the whole committee, anyone want to offer any thoughts on this draft?
Yeah. Gosh, I really like it a lot. And I didn't have the sense that, I didn't actually have the sense that it was overlong. I thought it was also appealing that it's an opinion, even though it doesn't conform to our rules, because it doesn't have a hypothetical, right? And it doesn't analyze the hypothetical. Even though it doesn't conform to the rules, I think it's excellent in its analysis of the issues. And I thought that, I had a sense last time that there was a little bit of advocacy in the draft, and I felt less of that. Maybe it's because the advocacy in the first draft was so successful I don't recognize it anymore. But I felt that this was a very down-the-middle statement of the critical propositions, and that it provides a lot of guidance. I wouldn't favor complying with our rules and adding a hypothetical, because I think that would constrain the discussion too much. So that's, I don't know that it's worth working through this. I think it's probably more useful for me to pass on my comments, which are relatively minor and involve more like where you preview certain points, or whether you should feature Professor Hillman's points, 2 paragraphs of Professor Hillman at one point, and or maybe just make the argument yourself. Minor things, but I didn't see anything that I thought was wrong at all. I thought it was clearly right, clearly helpful, clearly in advance beyond our earlier opinions, and clearly likely to become a kind of Baedeker or travel guide, for people who do this kind of work. So that's just an overall,
I agree with your comments. I think it's it's an important issue, and it does come up quite often. I think I probably dealt with this kind of issue 3 or 4 times in the last 3 months, let's say. So it's definitely an important issue. I think the opinion is, I didn't get a sense there was a lot of error in here, but it probably could, like any writing, be tightened up. And I think it comes to the right conclusions, even without a hypothetical. And I'm, you know, it's interesting to me when you read the older ethics opinions, very seldom do they employ hypotheticals. That seems to be an innovation that's only taken hold in the last 20, 25 years. I still think the old opinions, short though they are, often offer very valuable guidance. So I don't think the lack of a hypothetical is a problem here in these propositions of law. And this is important, I think, because in my experience, there is a lot of movement going on, and we often have the departure of associates from firms, sometimes under circumstances where there's conflict between the associate and the firm. And I think this would be very valuable for people in that position to understand what they have to do when they depart.
Yeah, and if just to briefly just address the point about the structure not being that hypothetical, that was something that we had talked about before in the prior group, and the consensus was that this was more helpful in this format without a hypothetical, and obviously there's new people who could have a new view on that, but that was what the group had concluded before on this particular
I agree with that choice. I mean, I think it would be too difficult to have the kind of typical.
We could have a hypothetical that say an attorney decides to leave.
There you go.
I'm not kidding, actually. I mean, I think to the extent the rule requires it. But yeah, it's like.
Leave it broad.
Two sentences.
I think it's missing a conclusion.
It is missing a conclusion, but it's also not a final draft.
No, look, as somebody who's been through this a couple times personally, I thought this was great. And I actually think it's pulled out the, I've been struck, I've got a couple cases I'm dealing with now that have to do with non-lawyers leaving and trade secrets and poaching and whatnot. And I thought this was a very good opinion that talked about the sort of the difference between we're lawyers and your duties to your client. You can't have the same sort of trade secret and poaching issues. I do have a question that just came up though, which is what happens, and does this address, it talks about associates leaving and the duty to advise. Usually when an associate, or not usually, but sometimes when an associate's leaving, it's a Friday afternoon, pack up your stuff, get out of here, you're leaving situation. What would the duties be for that? And I don't know, would the associate have a duty? Would the firm have a duty? Does it not matter because the partner is the attorney?
Primary.
Yeah, I mean, I think the opinion addresses the situation that it doesn't matter whether your designation is an associate or of counsel or partner. It really relates to your relationship with the client. And and this kind of dovetails off that ABA opinion, where it's like if you're the primary attorney or one of the primary attorneys responsible for the client's matter, then you have that obligation. And ideally, it's an obligation that, there's a joint notice component to it with the firm, but both the attorney leaving and the firm would have that obligation. I think that's the conclusion of the opinion. And I think there was a paragraph that I took out about, to the extent possible, communications to the client should always occur sufficiently in advance of the actual departure date. I mean, we could look at that and does that belong back in? I mean, I was looking to kind of, and I think in one section I felt like I effectively kind of streamlined a particular section, but candidly, and it's the problem you have when you write your own stuff sometimes is reviewing it too, is like, well, not that anything's so precious it can't be cut, but I did think to myself, well, that's an important point to make, or at least I think so based on my practice, and so some things were difficult for me to decide to, to cut out.
And I'm not saying this should be in it or not.
And I
Yeah.
actually didn't even think of this point until David said something 2 minutes ago, so I'm probably
Well,
not
no,
thinking
there's
it
no
through.
actual, like, notice is, the concept is reasonable because you're basically talking about prejudice to clients, right? So what's reasonable to a client, that's case specific. And also attorneys will have obligations to their firm too, and that in a partner context, right? That could be a more of a fiduciary obligation, but you're really talking about when, if you're saying that an associate walks out the door on a Friday afternoon, well, you're really looking at it from the lens of like, well, what does that do to, how are you prejudicing the client by that? And really the notice should kind of be guided by what's in the best interest and for the clients in that situation. And, you know, is it fair to give them more time to contemplate choice of counsel, to have a smooth transition and those things, you know, but there's no set notice, like 30 days is reasonable and, you know, one is not, or, you know.
I was asking, what if the associate gets fired? You're out of here.
Yeah,
You're
okay.
leaving. Do you have to
Yeah.
give notice to the client of, I mean, you can't do it then because most people, if you're fired from your job, are not given 2 weeks notice for.
Right, okay, I didn't understand you. I thought you
Yeah,
meant like a
no.
departure. Okay, sorry.
So if they're fired, would the firm have an obligation of them saying you can go with this 4th year lawyer? I mean, nobody's going to want to probably, but.
I mean, I think it goes back to the question of what's a significant development related to the representation, and if that person, regardless of what their stature was really intricately involved, I think the firm at the very least needs to tell them that person's left, right, and tell them what that means for their case, and that, you know, and I assume that if that attorney, I mean, whether they need to send out a choice of counsel letter, that this doesn't address that, whether, you know, in that situation, but I would tell my clients that's a kind of an analysis that you would do depending on that, you know.
But, you know, if a partner was terminated by the partnership, for example, and was asked to leave the premise right away, that doesn't mean that that departed partner couldn't do a notice to the clients.
Correct. And should really.
And should, right.
Yeah. And that, you know, those types of abrupt, if they were really like ejected or in a formal sense under the partnership
Ejected,
agreement.
that's the word I was looking for.
In that way, or,
Mhm.
or you know, expelled, or however you want to say it.
Right.
That has implications the firm needs to consider for clients too, like what, you know, whether they want to do them. If there's some extreme situation where, again, you can envision something where they had to let go of that person immediately based on something very serious taking place,
Right.
that's probably going to trump that. But in the normal course of things, you would want to allow time for that.
One thing that I wanted to say was that one thing that I really liked about the opinion was the section on the transition period, because that's something that I hadn't really thought that much of. You know, we advise clients, okay, you have to do a notice, you have to let the client know that you're leaving, and these other things that you should say, where you're going, how they have a choice of counsel, etc. But the idea that the firm and the attorney have to work together during the transition period to make sure that the client is not prejudiced, that you should let the client know, you know, what is going to happen to the case and the file while the client is making the choice, like pending the client's choice, for example. That's not something that I had really considered before. So I would like to, I think that's something that I would like to sort of like develop further.
Can I get a little input in the specific case? One of the cases I found recently, the scenario was associate works for law firm. She does most of the work on the dissolution case. At some point, she gets fed up with the law firm and says, "I'm leaving." So she goes to the partner and says, "Here's my proposed 1985-86 joint communication letter." Gives it to the partner. Partner says, "You're trying to steal my client. You clean out your desk. You get 15 minutes to leave." Thereafter, she departs, and she gives notice to the client she's departing. She departs, but the law firm never communicates to the client, and essentially thereafter abandons the client. So I think it's got to be a separate independent obligation, I think, by both the law firm and the associate to tell the client that I'm leaving, because I could see situations where the associate says, "Well, I thought the firm would tell the client." The law firm says, "Well, I thought the associate would tell the client." And admittedly, hopefully this doesn't happen very often, But there could be situations where somehow notice to the client, diffusion of responsibility. I thought you were doing it, you thought I was doing it, but neither of us were doing it. So I think it's got to be a separate duty on the part of both somebody at the law firm and the associate to let the client know, because there's a possibility that things will fall through the cracks. A worst case scenario, but it does happen.
Although it always seemed to me that the associate, if the associate isn't planning to take the work, right, I remember when I left my firm many years ago, I wasn't planning to take any work with me, right, and I didn't think of myself as having an obligation to let my clients know that I was leaving. I figured the firm would take care of that, and ordinarily I would think that if an associate isn't planning to take the work, that they could ordinarily rely on the firm to do that.
Well, yeah, I kind of like the idea of that.
Or at least if they understood that the firm was going to do that, they wouldn't have a firm
Right, well,
obligation.
I think consistent with the ABA opinion, if the associate's been the primary lawyer responsible for the representation, I think they should have a duty to tell the client, hey, I'm leaving the firm, not, in this case, the associate said, do you want me to represent you? And the client said no. But the result was there was about a 6-month period where the client had no representation. Thanks mainly to the partner at the law firm who was less than diligent, let's put it that way. So I think there should be an independent obligation. If you're the principal associate, I think you owe it to the client to let them know that you're leaving. And someone else, I've worked with you closely for the last 6 months. You haven't worked with any other lawyer in the firm. You need to know that I'm leaving. And I think that's not an unreasonable expectation.
Well, I think that's in the opinion, although I'm looking at some red line that I took out as I'm saying that it runs to both the departing lawyer and the old law firm. But, I don't know.
Well,
But, I think that's in the opinion other places too. That's maybe why I took that out there, because that's.
yeah, I think it is in the opinion.
Can that be a punt of sorts? You can just say the person, the attorney, parentis, who are primarily responsible, and then not decide who's primarily responsible. Because I agree with Steve that, when an associate leaves a firm, a young associate leaves and jumps to the second or third firm or whatever, and there's 2 other partners on a case handling a client, it's common courtesy and probably smart to advise your clients you're leaving, but I don't know that an ethical duty arises when you're the 4th lawyer on a case to make sure that your client knows. But but the situation that David's talking about, where the associate was the only one that talked to the client for 6 months, I think it would be there. So maybe you don't need to define primarily, and I don't think you did. I think it was right for the record, but.
Yeah, I think there is a discussion about like sort of that primary person responsible, and it kind of goes through an analysis about what that would mean. I mean, if the client is you're the 4th person on a team and you're not integral to the legal services, I 100% agree that there's not an obligation. I mean, you may find that, and that rises to the question of whether it's even a significant development that you would tell the client in that way, although they're going to maybe know this person's left the firm, new person's now in the case, but so I wouldn't think that would rise to the level of that situation, yeah. So.
Drew, do you want, looks like you
Well,
have
I had made a bunch of comments to myself that I think relate to places where it might be able to be shortened a little bit, because I think one of the last comments from you I remember hearing was, I'm looking for ways that, maybe I can make it not quite as long, although I agree with a lot of what people have said about, substantively it's important, so it's hard to cut stuff out. But I don't know if it's better, if it's good to go through that now. So I have a lot of comments like that, which I can give you sort of offline, so to speak. I do have a substantive comment over on line 180. And you're making this point about how you might need to notify a dormant client. But then you go on and you have a sentence that says there may also be circumstances in which past or former clients should be notified of the attorney's departure, particularly if it's anticipated that these clients may wish to employ the attorney in the future. And I was just curious what you're thinking of. What type of situation would the lawyer have an affirmative ethical obligation to notify a truly former client that he or she is leaving? I get the dormant client thing because they're not a true former client. But do I really, I mean, even if I know someone likes me and they've come to me, 15, 20 times over the last couple of years, sure, from a business standpoint, it makes lots of sense for me. I'll probably tell them I'm moving anyway. But from an ethical standpoint, what would be the situation where I have to tell a former client that I'm moving to another firm?
Yeah, that's a good point. I mean, I think what I was contemplating, which is really kind of tied up in that dormant client concept, was just like a client that's, maybe a regular client of yours that you don't happen to have an active matter with at that particular point in time, that they would come back to you, that they would be interested in having their file transferred to you if they were going to continue to use you as an attorney, so it would be relevant to your move from the firm. But I see your point and I think that in that situation, I guess you would be analyzing whether you think they're a current client with no active matters or whether they're truly a former client, and and what that's that's a good point.
Well, I'm open to
but
it.
I think it could be massaged in a way that makes that because I don't know if anyone has any other views about that, but
I think it makes good business sense. I'm
It
having
certainly
trouble
does, yeah.
seeing how I have any duty to a true former client other than my duty of confidentiality and my residual duty of loyalty. I mean, beyond that, I don't think there's much.
So maybe it's the concept of the current client with maybe no active matters, but you still consider them like a client that you.
That's kind of the dormant.
Yeah, which is the dormant client concept. Yeah.
Okay.
Yeah.
Isn't a current client with no active matters a former client until they have an active matter?
Depends on how you set the engagement agreement up. You should do it that way. Okay. I have a couple of comments, Dina. One is on page 10, lines 368 to 370, where you talk about at no point should the law firm withhold information from any client that inquires about the whereabouts. And I wondered if, I'm not necessarily advocating this, but I want to raise it. Is there anything more that needs to be said about that? Like, there are many different ways that a law firm can, well, I'll give this example that has come up in my practice. The departing lawyer wants to have their outgoing email say, I've left the firm, here's where I've gone. The law firm wants to have the email say, so-and-so has left the firm, for more information, you can contact someone within the firm. And that person within the firm will then provide the lawyer's contact information, but that lets the firm know, have an opportunity to talk to the client as well. So I wouldn't be able to read this opinion and know whether the second scenario that I outlined would be adequate. I mean, I guess I could conclude that it was. I think I would conclude that it was. But I wondered if we want to flesh that out anymore because I've seen that come up.
Yeah, I mean, there are ways, it's similar to that, in which firms do things like not want all client calls to go through them to sort of vet them, or if it's a potential new matter, but they ask for a client that left, they say, well, why don't you, I have so-and-so in the office, you can talk to him. And so those are the types of things. And in extreme situations, people will refuse to give information, like they'll instruct an administrative person to say well, don't give them their current forwarding information, which is completely improper.
Clearly be improper.
Yeah, so maybe that could, a sentence about that or two, yeah.
Well, I mean, I think that is what you say.
Yeah.
That is improper, and maybe that's sufficient, in which case doing something like, running it through, requiring the clients to kind of run things through a live person at the law firm is not problematic. As long as that person at the law firm is providing the accurate whereabouts of the departed lawyer.
Yeah, I mean, yeah.
Oh, Dina, I had one. kind of relates to how the firm and the departing attorney deal with the issue.
On that point?
Kind of related, because it has to do with the notice, whether it's joint or separate. One of the suggested content is the departing lawyers and the old firm's ability and willingness, or inability and unwillingness, to continue to represent the client. Are we saying that, let's say it's the lawyer doing the notice by himself, that the lawyer has to say that not only he or she is willing and able, but that the firm is as well? Or can the lawyer be silent on the firm's ability or willingness to take on the client, but then, say you do have a choice in whether you want to stay with the firm or with me or with new counsel?
Well, I think it just ties into what's kind of in that ABA opinion, but then is in Rule 1.4, like that A4, which is just basically telling them about your limitations. And so you're not going to, if you're giving notice to a firm and you're no longer handling particular types of matters, or you're not, I mean, I guess whether that content, you want to let them know that I think both people want to let them know that they are willing and able to handle the matter. That's kind of the general.
But you can only speak, right? But you can only speak for yourself. Like
if it's a joint notice, yeah, you're not. If it's a unilateral notice, you're not going to say the firm's incompetent and they can't handle the matter since I'm gone, right? I mean, that wouldn't be advised.
or say both the firm and I are willing and able, and it's up to you.
I wouldn't. That's that goes to more of I think an advice question, but I don't think that you want to represent the questions about the firm if
right.
You're not comfortable doing that. But we could say and/or the old firm's willingness, and you wouldn't represent. I wouldn't think.
Right, it was just the way it was phrased. I just wanted to make sure that it wasn't. You weren't suggesting that the lawyer doing the notice also had to say something about the firm's willingness and ability.
Can I?
All right, sorry, Amy got derailed from her comments too. She was in the middle of going through them.
Sorry.
Okay, so I also have a question about this whole Section E, communications following as part of lawyers' move, and about solicitation, because my question is that discussion about soliciting client, is it about existing work, like clients who the lawyer is working for at the time, or about something else?
No, it's about, so I took out this other longer section based on your comment at the last meeting about solicitation. It's about, this comes up all the time in departures where the firm says you can't solicit clients of the firm. So firms say this a lot, and attorneys say this a lot to other firms who are leaving. You can't solicit the clients of the firm. So the question comes up, and I've had to submit declarations on this point before, whether or not an attorney can solicit a client a current client of theirs at the firm that they were involved in the delivery of legal services for. They may not have been the only person, but right. So I think it's important to say that you're allowed to do that you're allowed to solicit your current clients, and it's not really solicitation, right? But that's the concept that comes up all the time. People ask about it, whether you're permitted to do it. And I find it interesting that it comes up all the time, but honestly, it does come up a lot for me in my practice where people are confused about that concept. That anecdote that you just mentioned, I hear that more frequently than you would imagine from firms saying they can't steal our clients.
Right.
And I still find it is sort of like a cultural and generational thing to some extent, but that's a concept that comes up a lot. So I feel like it's helpful to say to people that, and maybe it needs to be reworded to say this is not, I think it says it's not an improper solicitation, but it's not, you're permitted to contact your clients, and you also permitted to say, I would like you to come with me to my new firm, and then the questions are raised about, so it goes beyond notice, and it goes like, I want to continue to work with you, right, and be your attorney.
Right. So I would like to see it tied to the communication section, because it's not different, right? We just get through saying the lawyer basically has to solicit. They have to, at least in the mild form, they have to say, I'm leaving, and I'd be happy to represent you at my new firm.
Well, and
Right.
more than that, the notice has to say all these things like whether I'm able to represent
Right.
you, what
And
kind of
that-
law
and
I'm gonna
that is
practice.
solicitation, if you, I mean, you could call it that. So I totally appreciate your point, Dina, that because you see this coming up all the time, we need to say, you know, to the extent that communicating with your current clients is thought of as solicitation, it's certainly,
Okay.
you know, it isn't something that is prohibited. To the contrary, as discussed in the prior section, it's an ethical obligation.
I agree with, I actually had the same reaction when I read this again recently and got to that section. I found myself wondering, is she talking about someone who leaves and it solicits firm clients other than clients that they work for, and how often does that happen? So I was a little confused by that. I mean, I get all
Okay.
the points, and I
Yeah,
totally
yeah,
agree,
yeah.
but
No, I think that will
I agree it should
clarify.
go with the
I mean, I think
communication.
it does become a little bit more complicated during that period before, you know, you've given notice to your firm and then before you actually depart. And beyond, like, notifying your clients that you're doing something and saying, like, I am, and this is always like one of those gray areas, right? Like, I'm going to be practicing the same area of law and I'm willing and able and, you know, would like to continue to work with you. Is that just really a notification and giving them choice of counsel? Is that a form of solicitation? And then obviously people do say things on the phone with clients like, you should come with me and, you know, I'll charge you less, or I'm going to do a better job. And like, that's active solicitation of that client. And I view that as permissible. And I think it is permissible. And your firm can make, there can be arguments, like we said, about other stuff about interference, but we won't get into the legal claims on that. But so I think that's where it's probably, this evidence is like my attempt to kind of grapple with that aspect of it, where it's like you're communicating, you're notifying, and then when does it actually become a solicitation? And when it does, is that okay too, or is it not okay? And when, you know, that's, I guess, where that needs some
You make
clarifying.
I wondered, because I wondered, you know, a lot of what could be attacked as solicitation is probably just stuff you have a duty
Yes.
to communicate, right? If they're going to make an informed choice, they need to know things like
Whether you'll be cheaper.
yeah,
Yes.
exactly.
Yeah. And how many people are going to be working with you? And
Yeah.
you know.
It may be worth just not making it a separate section, Dina, but having it, you know, flow from the discussion of the notification.
Well, it's in the communicate, so it's like in the section of, it's D or whatever, so the duty to communicate. I mean, it's in that section, but it's E, and it's under communication following departed lawyers' move. So, but I think the way you're
Right.
suggesting, like, I could structure it differently, like to the extent that, you know.
Yeah, especially because solicitation is, and I'm sorry, I've been in and out in terms of focus here, but solicitation is so much about your things you're allowed to say out of your own self-interest, right? As opposed to things you're required to say. As a matter of informing the client, and as I read your opinion, and particularly this is one of the reactions I had to your long quotation of Professor Hillman, I thought,
I'll take it out.
I'm teasing you. But the thought that I had was, gosh, you know, there's more space here to protect this conduct, because whatever the firm can bar fiduciary duties in the firm, right, can bar solicitation, but they can't bar required informing under Rule 1.4.
Right, and what you do in furtherance of that required communication, so that the clients can make the informed choice, like that.
And I think beefing that up and making that point would be a service, because I think from an ethical point of view, there's, you know, there's more bite to 1.4. It has more oomph to it than many law firms would like to recognize.
Yeah, it does particularly. Yeah, it does now, right?
I think you're on to something about how to work this. First, let me say, you're the state's expert in leaving law firms, and I refer people to you, and I hope they call you, because they say you ought to call Dina. and you know all this so well, and you really cover the field with this, and it reads like a horn book. Everything you ever wanted to know with the law of leaving law firms, and so that's great, and I don't want to be guilty of saying we shouldn't do something just because we normally don't do it like this. I don't want to get frozen into that kind of rigid way of looking at this, but I did look at the rules for our committee, and where it talks about what has to go into an opinion. It says that it shall have a statement of issues, it shall have hypothetical facts, and it shall resolve them. And then it refers to resolutions, to three resolutions. Board of Governors 79, 2004, Board of Trustees, as late as November 2016. So this doesn't, then I scurried through our ethics opinions over the last 3 years. It doesn't really, it doesn't read like an opinion. It's more of a, if I went to law school again, and I say I want to take a branch of professional responsibility, leaving law firms, I would go read your horn book, and then this to me reads like a horn book, and because you tried to cover so much, it's very lengthy. Its expertise really shows, and it's interesting, and it's educational, but I wonder how it fits in what we're used to the format, and what I mean, it does have mandatory words here that the opinion shall contain, that the opinion shall have this particular structure. And they have this. Yeah. Your opinion doesn't tell a story. That's the way I'd criticize it, and it's long, and I think people learn and that's why our opinions, why they tell a story, because it's easy to remember. It's easier to learn when you're listening to a story. That's just my view of it, and I think you're trying to do too much. There's nothing wrong with what you say. It's all accurate, and I thought all of it was non-controversial, and it was just black letter law, and I would go consult it as sort of an encyclopedia of law of leaving law firms. But if I can double back to what Stephen said, which is an interesting hypothetical, it would be a law firm that develops rules in its partnership agreement to talk about what you can and can't do when you want to leave a firm. And those rules can collide with the rules of professional responsibility. And then you use what you know to tell people that's unethical to have those kinds of rules. And it's unethical to take the following actions when a lawyer attempts to leave a firm or attempts to contact a client. That's a good story. That would be a way to reconsider the structure of this. That's my reaction to this. I admire how much you know about this. You're a great expert.
Well, that's not really the point here. I mean, I think, but I appreciate those comments, and okay. I think that first of all, in terms of the issue digest and that part, that just hasn't been completed yet because of the draft. So that's intending to be there. In terms of the issue of the hypothetical that you raised, and obviously I'd be interested in feedback from everybody on it. I mean, to the extent when this was not in this version, that issue was raised and there was a conversation about it before I dug in and took this lengthy approach to doing it this way. And I'm not adverse to the concept of we could come up with a hypothetical. It could be as simple as what Amy said, which is like a lawyer's leaving a law firm. But if people want to weigh in on that, we have a new committee about those, and someone wants to help develop a hypothetical. That what you're describing is certainly an issue that comes up, and whether it would address all of these issues, it could potentially, so I mean, other people can weigh in on that concept.
Andrew, I want to ask you, so is there a way for us to get an answer as to whether there's any circumstances under which we can depart from that? Other than, I know you've said before that we could do like an article rather than an opinion. But I'm concerned that doesn't have the weight and I think that this opinion should have weight. So is there anything, or are we kind of just stuck with those 6 bullets that we looked at? Yeah, I think we talked about that too, and
Similar to an article.
yeah.
This is Kendra. Can you hear me?
Yep.
Yes.
I agree with Amy. I think we need this to have the weight behind it and that it goes much better as an opinion than an article. And although I like Amy's suggestion of having a very basic, maybe hypothetical in there, but I think Dina's opinion is excellent. I mean, when a lawyer is going through the situation or a law firm and they look at this opinion, these are the questions they're going to have. If we try to narrow it, the reader's just going to have more questions and want more answers. And I think this does a very thorough job of going through it. And quite frankly, we need it out there because there's not much there that gives this information. And it's a very important issue.
I agree.
So my recommendation would be just to have a general couple sentences setting forth the issues to be analyzed. Those, we don't have to have Bob one day went in and talked to his lawyer Mary. You know, it doesn't have to be. I know no one's suggesting that. I, as you know, use the argument of the absurd to prove some points which sometimes aren't persuasive. But all that to say, although it says a hypothetical facts and ethical question presented in a general manner, that can just be a couple sentences. It doesn't have to be detailed. You know, this ethics opinion is going to analyze the duties and obligations present when a lawyer seeks to, whatever we want to say. I mean, that's arguably a hypothetical. It's a general statement.
Yeah.
So I wouldn't let that discourage you, and it doesn't have to be complex.
Yeah.
We've made many times, oftentimes we make them complex, not necessary here. But I think it's worthwhile and relevant just to put a statement in front that precedes the analysis.
Yeah.
Correct me if I'm wrong, I don't think that would sink the
And Dina, where necessary, inside of the opinion, gives examples to illustrate whatever points that she's discussing. So you have like mini hypos throughout,
And this
which is
really,
helpful.
Yeah, thank you. This is like also to address that. I mean, this is really, as you know, just addressing the ethical issues related to departures. Obviously, there's, as we've talked about, that whole other stuff. So this isn't like the be all end all, but from what our job is as a committee, it's like this is the ethical framework to look at these issues from, right? So
Yeah.
hopefully that comes clear too, that there's, and we just put them in footnotes, but that there's other issues that people may be wise to consider, but that's not what this is about. Yeah.
Well, I mean, I think, Matt's point is interesting that when you frame it as a story, it's more engaging. But the downside is you almost always, a story is going to narrow what we cover. And also the story that Matt is proposing is actually one of the most, like, to directly take on, can a law firm like have a partnership agreement that requires X, Y, and Z?
Well, they do. I've seen it.
Well, I know, but
Dina knows it. She can tell you all about it too.
I'm not saying this doesn't happen. I'm saying that it's like it tees up as the center of our argument the very thing that there's a 75% of it we can't opine on, right? It's the and she does a great job of saying, look, there are fiduciary issues that they're in conflict with this. But I think I mean, I hear you, but I think it's sort of it makes the I think it would be pretty provocative to have
a reason to write it.
To take that on.
Have that opinion.
Is that a for or against?
It's a statement. But okay, can I just whip through my other comments real quick? All right, so I feel like sometimes though we, not everything, sometimes I feel like you veered a little off from tying it to the ethical duty.
Okay.
So for example, when should clients be told? And you say notice should not be used by the lawyer or the old firm with the goal of getting to the client first or prohibiting or limiting the other party from communicating to obtain some sort of competitive advantage. And I guess I don't have a big point, but I would like you to think about whether, for example, is it is it the notion that a law firm can't
Wait, sorry, what line are you on?
notice, it's the lines 219 to 222.
Okay.
I guess I think that it seems to me that there's no question that limiting or prohibiting one of the parties from talking to the client is clearly problematic from an ethical point of view. But having using notice to get to the client first, I'm not sure that that necessarily bumps up against the ethical rules.
Well, what I've seen take place, and I was trying to capture maybe here, I'm in terms of thinking, explaining why maybe I put that concept, is that like I've seen this play out many times where there's a discussion about potentially a joint notice that will go out between a party person and the law firm, and it's like there's been a proposal, and then the firm will say things like either in their rules or personally to the attorney, like, don't talk to the clients because we're working on this, and they use that as a way to delay this formal notice letter to go out while they actually call the clients and talk to them, but they tell the attorney not to do that. And so I've seen that notice as like being used in a way that I think is completely improper for the purposes of really what you're trying to do, obviously communicating to the client about that particular issue and not putting the client's goals first in terms of that. So, I mean, I certainly can take that sentence out. It's about not sort of using that notice for anything other than the purest motive of what it's supposed to be, which is communicating that basic information about the departure, not using it as, yeah, we definitely should send out joint notice because I think that's what the rules, the opinions say is proper, but we need all this time to look at it, and then using that time to kind of do what I described, which I've seen happen many, many times.
Yeah, no, I'm sure.
And then it's like, oh, we're not going to send out this, or we're, do we really need to do that? And it's, and so that's the concept behind that sentence, I think, although I need to read it in context of what,
Yeah.
what I wrote. And I'm not adverse to leaving it out. I'm just saying.
Yes, this is Kendra. I have seen that happen many times as well.
But is it unethical? I mean,
Yes, because the attorney, it's a significant development in that particular matter, and the attorney should be able to notice the client, and the firm can't say, you cannot speak to this client until we've done that written notice letter and sent it out together. You can still speak to the client before a written notice goes out. But to prohibit the attorney from giving client notice of a significant development in their matter, which also, takes away the time for the client to make the decision of their choice of counsel and all of that. I've seen firms use it, as a sword and a shield many times, and in an improper way as well.
Yeah, obviously, it's certainly true that if you use it, if you use the notice in a way that causes the client not to have sufficient time, then that would be ethically problematic, because we've said that the client is entitled to sufficient time. But I guess all I'm saying is I just want us to be careful so for example, if the lawyer said, I'm leaving in 2 months, and the law firm said, okay, we're leaving in 2 months, let's put together a notice, and then did exactly what you said, they kind of did the sneaky thing. They said, don't contact the client because we got to do the joint notice, and then they contacted the client. There's nothing pending in the matter, so the client is not going to be prejudiced by, needing to make a decision soon. I'm just questioning whether the ethics reach so far as to say the law firm can't behave badly.
Well, I just think.
Well, you know what? Sorry.
No, go ahead.
I was going to say what I've seen happen in that situation is they'll say, okay, your last day is 2 months from now. They take their time on the letter, and then after they've contacted all the clients unilaterally, then they say, you know what? You don't need to wait 2 months. You're out tomorrow, or you're out today.
Yeah.
And then the attorney has not had any time to contact the client, and they're no longer present to collect the file if the client does decide to go with them. So then they're struggling. It just makes the transition much less smooth for the client. So it's just the playing games, and the important part is that it's the client's interest that everyone has to have at heart.
And I think if
So
we had
it ends up harming the client in the end.
I think if we had a sentence that said any action that makes the transition less smooth for the client is, ethically, problematic, whatever the words is. I totally agree with that. And I guess maybe my point is not valid in the sense that if the goal of the law firm is to keep the client, then maybe all those steps that they would be trying to take, like you can't contact the client until the letter goes out, are designed to sort of limit the client's choice, which is what we're saying you can't do. So,
Although,
yeah.
I think we have to be careful, though, to not, whatever we say in that regard, we got to be careful that we're not going a little bit too far, because you do have these other corresponding duties, which are the fiduciary duties, right? And if you said anything that is other than what would be most, desired by the client, I mean, a client would like to know probably the day the lawyer's thinking about it,
right?
Yeah.
But
you can't necessarily tell them, and there's a recognition that you go to the firm, you tell the firm, you try to do this jointly and so forth. So, I mean, it can't be quite so definitive as, anything that would have, been theoretically perceived as better from the client is necessarily.
I'm sorry, you're right.
No, that's just,
I think this could be reworked. I mean, I think that the concept that I think would be nice to keep is just the idea, because I do think it's about informed choice ultimately. And whether it's the law firm or the lawyer who's trying to basically like monopolize the client's attention, give them information and say you need to choose now, without having the other party have an opportunity to convey that they would like to represent them too, and here's information about what it would be like to work with me, either at my new firm or if it's the firm's perspective. I have a great team that's going to step in and handle these matters, even though the departing attorney's left. That's the concept, I think, that is the ethics issue when you're asking that question, which is just sort of like you're not really giving them this balanced, informed choice because you're trying to monopolize the client's choice. I'm not saying pressure them to make a decision, but like put to them that issue before the other party has had an opportunity to convey that information in a balanced way.
Yeah. I mean, I'm not sure. I raised it because it crossed my mind when I read the draft.
Well, when you see probably the word like competitive advantage, I mean, I think that kind of raises a question about whether that's an ethics issue or more of a business issue. Maybe that language you didn't like. Yeah. Maybe.
And actually to your point, Drew, about the lawyer not being entitled, not talking to the client before they communicate to the firm, which you address at the top of page 7, which I think is a super non-controversial concept, but I'm not sure we can tie it to an ethics.
That's a very good point. I mean, it's an interesting question.
I mean,
Yeah, no, I
Where?
It's the top of page 7, lines 250 to 254. Just the concept, which we all accept, which is the departing lawyer needs to tell the firm before they talk to the clients, except in unusual circumstances. But it's not for ethical reasons.
I mean, it's much more of a fiduciary duty issue in the context of partners, right? I mean, again, if you want to further extrapolate that same concept I just talked about, which is like you're trying to give people you're trying to create a balanced playing field for the client to make informed consent and choice of counsel, and if you do that before the firm knows, I mean, it's a matter of like the advantage of time. I think that would be conceptually the same idea. It's in support of this idea.
So there is an ethical piece right there.
That would be the point, right?
It's sort of like there's an equality idea. It seems to me a lot of what we're talking about here is kind of equal opportunity.
Yeah.
And that equal opportunity is not
either party.
It's for the benefit of the client. The reason it's ethical is because the client, full information of the client requires an equal opportunity.
Yeah.
And so there is kind of an ethical underpinning to the idea that you tell the law firm before you tell the client. But then the sauce for the law firm is that they can't monkey around in ways that essentially prevent you from making equal the departing identifier. I am identifying with the departing lawyer, but prevents the departing lawyer from making an equal presentation, because that's not in the client's interest. Right. I mean, the scenario that Kendra was describing seems to me to be clearly unethical. Right? If you actually prevent the client from getting timely information about the alternative lawyer, right, until essentially the events have set it up so that as to make it highly likely the client will stay with you.
Well, I've seen scenarios where people have been taken off matters. They are told that they can, not to bash firms or whatever, just like they've been told, told that they can, their notice is 60 days or 90 days, and then they're at the firm, and then they're taken off matters, and they're restaffed. And so then by the time, we don't need to give notice until it's close to time for you to leave.
And then you're not on.
Then you're not, that's not really, giving the client, that's kind of getting in the way of that choice and basically taking you out of the.
Right.
So.
We can't,
It's interfering with your attorney-client relationship.
Well, probably the most useful thing here to do is to cast a shadow over those practices without necessarily opining with respect to all.
I agree. That's why I think, with going back to that hypo concept, is that this is an easier way to do that without kind of taking on things that may not be as well received by a lot of, I don't know, people.
Part of this also is, feels to me, there's this lurking thing about Babcock versus Wilcox, and
that horrible opinion.
It's really a bad opinion.
It is.
It's an outrageously bad opinion, and but it's out there, and it raises the question. It means that if you're going to go into this or that contractual provision is invalid, you have to deal with a sort of shadow of the bad view of things that.
Yeah, and it has no analysis whatsoever, and it just like some lines that are not helpful.
It's a very client unfriendly opinion that probably shouldn't be expanded, but it's not something we can take on very effectively.
No.
Okay. Yep. Sorry.
One other quick comment. If you are looking for places to shorten it, I kind of found myself on page 2, the opinion starting at 80 to like 96. This is interesting, but I wondered if all the stuff about compensation, I don't disagree with it, but the point is, client choice drives the decision and they're not property. And then, you go on for a while talking about why sort of the business aspects of firms create some of these misperceptions. I don't disagree with it. I don't dislike it, but I don't know if it's completely necessary if you end up finding yourself trying to, find places to cut it down. About how the firms compensate their lawyers and.
I liked that, I have to say. Particularly after the Heller opinion.
Yeah, I thought that's sort of why.
That's
Okay.
why to have it, right? Because the Heller opinion has now kicked that idea in the teeth, and it's good to get it.
Okay. Well, like I said, I don't dislike it, but it was just an observation.
All right, cool. So we will look forward to the next draft.
Okay, thank you everybody for that feedback.
All right, so I think we still have a half an hour before we're gonna stop this meeting and become a different meeting. And so if maybe like with a 1 minute in the room stretch break, let's shift to alternative litigation funding and spend 30 minutes on that. And then, right. At least 10 seconds of stretching.
I'll stretch.
Good. I'm going to need us in a sentence.
would be great. How about some jumping jacks?
Yeah, that's a good idea. Yeah.
Towards like the end of the flight, they have the video that comes on and tells you.
Yes. Can you turn off the video? No.
I did, but the video, the audio will still feed
Oh.
through the mic. So this mic is off. Yeah, I didn't wanna, sorry. We have to have a discussion about, we have to.
There wasn't that, the part, so then I kind of had to extrapolate, but then that rule, But it was like, I found it bizarre, that came up before this meeting where, in the overall special finding about like one of the grounds, you don't acknowledge the fact that the client fires you, like, that's a ground.
We're either closer to the.
See, obviously, you know, in certain contexts, you're gonna have to get the court's approval, and I'm not saying that, but it's just this concept that that would be, and that's in the ADA rules, and that's one of their prongs, and now it's. And then.
Marijuana, I rely on those. That would be really going to happen, and I'd like to reserve the right.
Kendra, you still on the line?
Yes, I'm still on the line.
Hi, Kendra. Let's, hold on, let me get on the mic. It's Steve. You may
Hi.
not, you may not know this, but there have been some conversations going on about the marijuana opinion, and with your, here you are on live mic, so you don't have to answer on live mic, but you can think about it.
Okay.
We're hoping that you can, you and I are going to try to take over the job of getting a draft, and we're hoping you might do the part that you've talked so wisely about at past meetings, the whole sort of question of what the lawyer has to say about, by way of all the disclosures about how things can go wrong.
Okay.
In the marijuana context. Yeah? Is that an appealing prospect for you?
I'm happy to help. I will have to get my mind back thinking of that again. It's been a while since I've been on that topic, but I'm always happy to help. So,
Yeah, I mean, that's the question. I guess, all right, we're gonna obviously spend a little time talking about staffing, so that's fine. So Kendra, you already, on impaired client, how much lifting is Kendra doing on that opinion right now?
I mean, she's offered comment, but, you know, if the question is, should Kendra best focus majority of her energy on marijuana, then I think that's fine.
Okay. So Kendra, we would protect you from a lot of duty on colleague impairment if you would agree to be added to the marijuana opinion and take on a portion of drafting of it.
Okay.
You can think
Deal.
about it if you want.
Oh, no, you better get me now.
Okay, awesome. All right, so yes, Kendra's added.
Okay.
Okay, so Kendra, I'll be in touch, because we're gonna be up next meeting to say something. It's in advance
okay.
over wherever we are now.
Yeah.
When is our next meeting? What's the date of our next meeting?
Who knows the answer to that question?
I
Mimi's gonna tell us.
usually. Do you know what it is? I bet you it might not be for you. January 11th.
Oh, wow. Right after the holidays, huh?
Oh, it's very soon. Oh, boy, that is gonna be a challenge. Well, we can do something.
Yeah, it
We
doesn't.
didn't,
we can move it
we're not, we
forward.
may not be able to get it. Yeah, yeah.
And make sure it has a conclusion.
Okay.
This shit is really good.
Yeah.
You should pay attention.
Yeah.
Yes, we are.
Sorry.
Hey, Steve, I wanted to ask you too, do you need anything more from me for my article?
No, just, I need, unless you have some time to give me. No, I need to, I've been derelict, and Eric and I are working now on making a transition and getting your piece out as soon as we can.
Okay, just let me know if you
Yeah,
need
we've
me.
had some glitches with internally at the bar with getting our stuff done too, so.
What are the
But
four
nothing, I don't need anything, so we'll be in touch about that very shortly.
that you have?
Okay, perfect. Thank you.
Marshall, that's right. But I'm not sure that Marshall does it. I would like it, but so we have to ask him. Well, I mean, I don't really well, there's Gina's on, right? And Owen, lost laptop. Lost laptop. What you're gonna do about that? Right, I know.
Circulate to the drafting committee a revised draft.
Yeah. That's fine. Both, but the problem with it is, the drafting committee is all people who is Steve and Eric who have asked to be prepared to, turn drafts. And so I guess we can do it anyway. All right. Yeah, I think so. Wait, but what is it? Lost or stolen laptop,
Attorney rating websites,
marijuana.
ancillary business, and prospective claim.
Right, if Marshall can do it, and if Marshall can't do it, I'll ask Dina to do
Another
draft.
version, yeah.
Okay, great. Yeah.
And we gotta talk about
Symposium.
That's why,
Yeah.
so I think we'll be okay, that's enough.
Yeah, I think that's good. All right. And I don't, people aren't precluded from circulating a draft of something that's not going to be discussed. They just know in advance that they're not expected to do it. All right. Okay. All right, folks, let's get back together. All right, so we, the first thing is that we're going to talk about ALF, but just quickly, what we're going to do next month, January 11th, our next meeting in the new year, is we are going to talk about the ratings, attorney directory and ratings website, which is, yeah.
we're going to talk about lost or stolen laptop, marijuana business, if Marshall can do it, the duty to a prospective client. If not, Dina, I'll probably come to you and ask you if you can turn another draft of the departing lawyer. And so that will be our plan. Anyone who's subcommittees who are working on things that aren't planned for discussion next month, of course you can circulate a new draft, and if people can read it, great. But we won't plan on talking about anything other than the 4 I just mentioned. Oh, plus we'll talk about Steve's the conclusion that Steve adds to ancillary business, which ideally he'll be able to circulate through staff before we even meet, so we can really push through that one quickly.
So you're gonna get an assignment agenda that looks like every other assignment agenda, except I'll highlight the 4 or 5 that we're focusing on. Just because I still want you guys to have the full list with who's assigned to what.
Agreed.
But the highlighted ones will be the ones that will be discussed at the meeting.
Okay, so let's take 20 minutes to talk about, 20 minutes to talk about alternative litigation funding, which is 103 to 120. I have to confess, I made these changes so long ago, I don't really remember. I don't have anything really to say. I know there's a lot of changes. The red line is pretty heavy. I think I changed some of the facts and then changed the analysis as a result. Really interested in any feedback in moving this one forward. Drew.
Well, I think I may have mentioned this outside of our formal meeting, and I'm just going to throw it out there, but there's one issue we don't talk about is the issue of sharing the fee splitting. And there's a recent opinion that came out of the New York City Bar that said if it's non-recourse, it's a breach of the rule. And there's actually, I had forgotten about this, an older, quite old, I think, from maybe the early 80s San Francisco bar opinion that talks about non-recourse and sort of reaches the same conclusion. And there's been a lot of opinion in articles and press about the New York City decision, which is, let's see what the number is here, 2018.5. So it came out just within the last several months. So anyway, I'm just throwing that out there. I know that there's probably some people out there that are thinking, well, if there's going to be another ALF opinion, and there's one coming from California, a lot of people think that New York got it wrong. And so I just throw out there, is that an issue we want to even broach? Maybe we don't, maybe we do, but it is kind of a hot issue right now, partly because of that New York opinion and sort of pretty strong disagreement in some camps with respect to how it came out.
Okay, that's good.
So that's not to your content. I just kind of, and I think we talked about that. We sort of at one point we said, should we talk about fee splitting or something like that?
Yeah,
but,
and I know you sent me that opinion and I haven't read it. Okay, great. I will look at that and try to figure out whether it's something that can be fit in.
-5. Well, I have another.
Yeah.
Just in our statement of facts, the first scenario, we talk about the lawyer represents a client with a personal injury claim who's in need of money for living expenses. Then he goes to the litigation funder. I'm posing the question, but from the things I've seen, usually the litigation funding agreement is tied to requirements that the funding be used for purposes of the litigation. Or maybe I'm wrong. I mean, can you go to a litigation funder and they say, well, for a percentage of your potential recovery, I'll give you money that you can use for your own completely personal reasons?
Yeah, I mean, I think that's what consumer litigation funding is. I mean, I think it's like a payday loan. I mean, it's,
Okay,
you know,
all right.
it's very, very different animal from the commercial folks.
Okay.
But I think generally that's exactly what people do use it for.
Okay.
Like plaintiffs who are injured and can't work.
Yeah, okay.
Okay, well,
I like the changes a lot,
thanks.
and I think it's very very close. I didn't actually see anything in there that I objected to.
I was wondering whether the $5,000 payment that I put in the first typo is too, is stupid.
Like really, as a lawyer, going to accept money and not tell the client that they're getting money? I mean, I thought maybe if I made it a little bit more subtle, like that the funder often sends the lawyer new clients, which also I think is something that probably needs to be disclosed. I mean, that's something I sort of talk about in the second scenario, the relationship between the funder and the client. But anyway, if it strikes people as really like so unrealistic that it's like not helpful, like it's so obvious that you would have to disclose that, you know, we could consider taking that out because it's not really advancing the ball.
It didn't necessarily bother me, but I don't know, I mean, in some respects it does seem to be extreme stuff.
Well, it's in there because the lawyer doesn't disclose it, so it's
I
in there.
understand that.
Oh, okay.
You know, just the specific amount.
Oh,
You know,
okay.
receipt of some consideration
Mhm.
does need to be addressed, but as in terms of $5,000 or client referral, I mean,
Okay.
I don't know enough about that aspect of.
Yeah, some consideration.
Yeah.
Okay.
I think if the board is good to, make a copy of it, it's helpful.
I mean, I could leave it in with the 5,000 because some people might think it's just so negligible that it's not. You know, depends on but obviously it depends on the kind of law practice you have, whether it's negligible or not. Well, I'll play around with whether I should make it more sort of a generalized point that they receive some kind of consideration and they don't disclose it. Any questions for y'all?
I mean, I think generally the discussion of and how you utilize scenario is reasonably better.
Yeah. Thanks.
And may have, yeah, I don't remember whose last meeting or last subcommittee call now quite a while ago, but it seems to have taken life or taken apart all of the draft.
Good. Good. All right. Well, it seems like maybe the main thing I'll focus on for next time is this this fee splitting.
I can add one other thing to that,
Yeah,
just because it's
please do.
interesting. Someone pointed out to me that one of the areas that I guess some camps are very sensitive to on that issue is, for example, in class action or mass tort type situations where there might be funding, and you don't have the option of, you know, the agreement being sort of between the client
Yeah.
per se. 'Cause the New York opinion basically says if the agreement's with the client, you're not violating the rule. But, you know,
Yeah.
if you have a situation where the lawyer essentially has to have the agreement with the funder, and in the Northern District, you know, we have a rule now that says you have to
Disclosure
disclose.
rule, yeah.
And so doesn't that sort of suggest that there's a recognition that
it's okay.
permissible and
Right.
okay? And so how does that square with,
Yeah.
you know, these opinions that are saying it's a violation of the rule?
Right. Well, that's interesting. That's a
And
good
it gets
point.
into the pooling too. Some of the more sophisticated funding where they have like a portfolio.
Yeah.
And you're not going to have one individual. You're going to have an agreement between the law firm that has a collective of individuals who may not be on their own, may not have cases that are attractive enough.
Right.
But a funder will fund a pool of them collectively, but the agreement's with the with the lawyer, so.
Right.
Anyway.
And there are also, and there are lots of advantages from an ethical perspective to the pooling.
Right.
Because the funder doesn't necessarily have such a specific interest, and they don't even necessarily know which they're funding. So there's less of the concern that the funder's going to want to try to direct things when they're
Right.
sort of spreading their risk.
Well, and it's my understanding that an awful lot of personal injury law firms operate on a line of credit.
Right.
So it's not so far, from moving to a line of credit to what you might call a secured line of credit.
Mm-hmm.
And exactly why that's
Why it's
bad.
different? What's the
Yeah.
problem with
Yeah.
that?
Well, some of the arguments you hear from people who are looking at this are things like, well, when you talk about independent professional judgment, who's going to have more pressure, to settle the case, and the person who took out a loan, the lawyer actually took out the loan and has to pay it back,
Mm-hmm.
or someone who's going to fund, the case, but there's no obligation
Mm-hmm.
unless there's a successful resolution. So, I know there's two sides of that coin, but anyway, it's an interesting issue. I'm not necessarily advocating that we have to put it in the opinion, but I've had a couple of people who know that there's an ALF opinion being worked on ask if that's something that's going to be addressed. So.
Yeah. No. It seems like there's a good argument. It sounds like for addressing it, if I can figure out a way to fill it, to work it in. All right. Well, if nobody else has any comments, then we can wrap that one up. Let's see. Anything else that we need to talk about in this meeting?
Just a reminder to send your suggestions to possible ethics symposium topics so I can compile them for.
And will you send out the list of prior as you always do? Okay.
You'll get it with the assignment agenda.
Do you want to send it out earlier than the assignment agenda? Because
The meeting's in like a month, I'll probably send the assignment agenda on Monday.
Oh, okay. All right.
Please don't send it over the week.
Over the weekend on Monday.
Yeah.
I'll send it early with everything.
There's nothing new about. So you Andrew, you covered the 1987 working group, right? That was.
No, we didn't. We didn't talk about that today. We did talk about it at the prior meeting. My assignment, which I did not get to, is to get for Steve all the resource materials that I'm aware of that pertain to the question for the legislature. A couple ethics opinions I can think of. Certainly the rule we're all familiar with. The assignment has not formally come to us from the board. I expect that that'll happen at the board's meeting in March.
And that's the one about the file retention, right?
It has to do with post-conviction files, what the lawyer's responsibility is with respect to post-conviction criminal files. Is that responsibility sufficiently raised and addressed in any rule of professional conduct or ethics opinion? If not, and I'm guessing at this part, it's actually in the legislative language when they passed the statute. If it's not sufficiently identified in any of those resources, what suggestive fixes might the State Bar have in order to raise that obligation to the attention of lawyers in such scenarios? I have an idea. I think it's fairly easy. But as part of that is, what is to identify what the existing authorities are with respect to that issue. And I owe Steve some research.
Okay, sounds good. All right, well, we might as well shift over, I think, if the few minutes ahead of schedule, but that's okay. Is that true? Is there any problem from the webcasting perspective?
There might be a problem. Yeah.
I know, it's bizarre.
So you may just want to take a 4 minute
We can't start
break.
till 3. Okay.
I mean,
How many people want to come and sit down?
Yeah, right. Yeah,
Well,
there's
The
more
clamoring
seats if you'd
public
like
was
to,
noticed that we would be
come
beginning
and
at
join us.
3 and,
We gotta be back with teams and plan.
Yes.
We know Mark Shriver was,
Oh, yeah.
yeah, committee for a very long time.
Right. Up until recently, right?
Yeah,
The last
last
couple
year
years.
was his
Oh,
last,
was it last year? Oh.
Traffic was bad, but not horrible. I was going out early enough for horrible traffic.
I think we all got lucky today with the weather.
Yeah.
So good afternoon, everybody. We're going to get started on the first ever joint meeting of the Committee of Professional Responsibility and Conduct and the Committee on Mandatory Fee Arbitration. Before we begin, we should take a roll call.
All right. Amy Bumsey. Stephen Bundy.
Here.
Kendra Basner.
Here.
David Carr.
Here.
Eric Deitz.
Here.
Andrew Dilworth.
Here.
Justin Fields. Matthew Hodel. Toby Inlander. Adam Koss. Amber Lee. Dina Roche. Teresa Schmid. Richard Solomon. Stephen Sparta. Marshall Whitney. Thank you.
For FIARB, Lorraine Walsh. Here. Clark Stone. Here. Lee Strauss. Here. Ken Bacon. Anahid Ajemian. Carol Buckner is no longer on the committee. George Dusiker. Here. Michael Fish is no longer on the committee. Jo Beth Halper. Jason Houston is no longer on the committee. Patrick Maloney. Joel Mark. John McDougall. Sharon McLawyer. Roy Zuckerman. Here. Thank you.
Okay, so for those of you who don't know me, my name's Andrew Tuft. I'm a State Bar employee. I work an attorney in the Office of Professional Competence. I work as staff counsel to the Committee on Professional Responsibility and Conduct. And I just want to welcome all members of the Mandatory Fee Arbitration Committee with us today. As I've been keeping COPRAC leadership apprised of, as well as the committee earlier this morning, of the State Bar's Board of Trustees review of all committees and commissions and their decision in September to sunset the Mandatory Fee Arbitration Committee, as well as transition some of their work to the work of COPRAC. And that part of our meeting today would be to discuss some of the work that the Committee on Mandatory Fee Arbitration is working on as part of their transitioning of their responsibilities and finishing up their work product before they officially sunset. And before we did that, I thought it might be helpful for the entire group if the chair of COPRAC, Amy Bomsey, and if Lorraine, if I don't surprise you by it, just take a few minutes to each discuss and mention what the charter is of each of our committees and give us all just a baseline understanding of what our committees do.
Sure. Would it be helpful if we just went around the room and said basically who?
Would it be helpful if we introduce ourselves first? I think some of us know each other, but some of us don't, and just give a brief bio of, your practice. I think that would be helpful.
Sure.
I'm not familiar with the microphone, but does it stay on when I'm not talking?
If you push the button, the red light will go off. That indicates the microphone is on.
I'll start. I'm Lorraine Walsh. I'm chair of the Mandatory Fee Arbitration Committee. I've been an attorney for 36 years. My practice is in Walnut Creek. I'm a solo practitioner. I'm also a certified specialist in legal malpractice law. In my earlier years, I defended lawyers that were sued for malpractice, and now my practice is mostly sued on doing plaintiff's work and obviously fee disputes.
Hi, Ken Bacon. I'm from Sacramento. I'm currently with the Mastagni Law Firm. I was formerly partners with one of your ex-members, Steve Lewis, who was chair back in 2010, somewhere around there. I'm also a certified specialist in legal malpractice. I'm the current presiding arbitrator for the fee arbitration program. I mostly nowadays do internal house risk management and ethics work for my firm, and some legal malpractice work still. So.
Hi, Eric Deitz from San Diego. I am with Gordon Reese Scully Mansakani. I do primarily professional liability work, representing lawyers and other professionals, and have been a member of COPRAC. This is my 4th year.
David Carr, I'm a solo practitioner from San Diego. I represent lawyers in state bar discipline proceedings. I give legal advice and I represent applicants before the Committee of Bar Examiners for the last 17 years. Prior to that, in my previous incarnation, I was a deputy trial counsel and assistant chief trial counsel in the office of chief trial counsel at the State Bar.
Hi, I'm Dina Roach. I'm with O'Reilly and Roach in California, in San Francisco, and in Los Angeles. And I am a member of COPRAC. This is my third year on the committee, and I provide advice and counsel to lawyers and law firms on legal ethics, risk management, and partner departures and attorney transitions.
I'm Sion Amber Lee. I am with Rogers Joseph O'Donnell in San Francisco. I do mainly professional liability defense and complex business litigation defense. And this is my first year as a COPRAC member.
Hi, I'm Sharon McLawyer. I am the program director of the Los Angeles County Bar Fee Arbitration Program, and I've been there since 1989. That's mostly it.
Hi, I'm Lee Strauss. I'm an executive vice president of business affairs at NBC Universal. You're wondering, why am I doing this? But I got into PR with Sharon about 20 years ago. So I've been an arbitrator for the Los Angeles County Bars program. I'm now a vice chair on that program, and then became part of this committee 5 years ago. And now I'm a vice chair with Clark.
Hi, I'm Clark Stone. I have a solo practice in San Jose representing technology clients primarily in litigation matters. I've been involved in fee arbitration for about 15 years, primarily at the local level in Santa Clara County as an arbitrator and presiding arbitrator and chair of the local program. This is my third year on the mandatory fee arbitration committee for the State Bar. Before I was an attorney, I was a purchaser of legal services. I worked for about 20 years in the technology business, and don't ask me why I left that to become an attorney. But
Hi there, Adam Koss. I'm an attorney in San Mateo, California. I do professional liability work, mostly attorneys and accountants, defense background, but now most of my work is on the plaintiff side.
I'm Toby Inlander. I'm the public member on COPRAC. I've just started my first year several years ago. I actually worked with Sharon at the LA County Bar Association and with the VR program.